ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಿಡಿಯೋ ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ ಕೋರ್ಟ್ದು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಾಹೇಬ್ರೆ ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ ವಿಡಿಯೋ ಕೋರ್ಟ್.
Compromise the partition for admission without finding tomorrow. Last week also I mad. What is the urgency? The execution file ಮಾಡಿದ್ದಾರೆ. Declaration and possession, divergent finding. And now the execution is filed by the tomorrow morning.
An extension of PM now.
Application is filed for Still number? Extra, this is an injunction suit. Satadra hoitala. No, injunction suit idu. No, mother. You are the defendant in the suit. Defendant tane. Court. Even then, this suit will not survive. This is a suit for injunction. If the person dies, then what happens? Possession again. If the person dies, what happens? There are suit file ಮಾಡ್ಕೊಳ್ಳಿ. File a separate suit through the LR.
Bill number 39. Council, our other side, but let it come. Yes.
Your options can be prepared. Serial number 43 will connected to the RSA 557 of 2019.
Opposite that, put up RSA 557 2019 along with this.
Yeah, that is for me, huh? Also, RSA number 2044117.
Bill number?
3134. There are 4 others are there. No officers there.
RSA number?
RSA number 2044117.
2045 21. Office that.
Appeal number 5 and the CP.
Office is there to put up this appeal along. Put up RSA number so and so along with these appeals. Yes. Yeah. The date given matter, I'm sorry.
Want to verify the
But yes. So regardless once the here ಮಾಡಿದೆ. No, it was already heard in part. That means ನೀವು ಯಾರಿಗೂ ಮಾಡಿದ್ರಲ್ಲ. You need to come up after vacation. After vacation. Serial number 52 at the request of the council for the list after vacation. No, either today or after vacation. Their case will Bharat Agudi, if you are not ready, let lawyers who are ready, let them listen. Please wait. Please wait. No, but this Mr. Who are the parties? Nanappa is heard. R1 and R2 appeal against stands dismissed. Harish H2 for R. No, the appeal is dismissed against R1 and R2. No, let us see. No adjournment. Yes.
My lord, serial number 61, my lord. We have engaged the senior counsel, my lord. That is inconvenience for senior counsel to appear before the court, my lord. Kindly have this matter in the next week, my lord. We have informed the other side also, my lord, which is regarding this.
No, this was already heard once.
My lord, we have engaged the senior counsel.
So you might engage a senior counsel, but this matter was this appeal was heard once or twice.
No, my lord, we don't have it already.
61. First time. Yes, when do you want?
My lord, in the next week, my lord.
You please pick a date of your choice.
My lord, on 5th month, 4th, my lord.
Request of the council for the appellate list on 4th as the last chance. Yes, correct.
Much
2 weeks time granted to comply the office. What is this clarification? Peruse the letter dated 14/3/2022, addressed by the senior civil judge and CM Mysore. Now that the records are received, by the senior civil judge and CGM, so the said court is directed to dispose of the appeal as directed by this court within a period of 6 months from the date of receipt of the copy of this order. Yes, ma'am. Process ಕೊಡಿ ಇವತ್ತು 2012 ಇನ್ನು ಎಷ್ಟು ವರ್ಷ ಕಾಯಿಸ್ತೀರಾ? Madam, respondent number 4 to 16, 18, 19, 21, 22, 25 to 27, 29 to 31 ಇವರಿಗೆ ದಯವಿಟ್ಟು ಪ್ರೋಸೆಸ್ ಕೊಡಿ. 1 week ಅಲ್ಲ, ಇವತ್ತು ಕೊಡಿ. ಸಾರಿ ಮೇಡಮ್, ಇವತ್ತು ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ appeal will be dismissed against these people. Madam, you should do it today. 2012. Please don't seek for further urgent. Counsel for the appellant is that. Madam, ನನಗೆ ಫೈಲ್ ಕೊಡಿ, ನಾನು ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಕೊಡಿ. appeal copy ಕೊಡಿ, ನಾನೇ ಪ್ರೋಸೆಸ್ ಕೊಡಿಸ್ತೀನಿ ಕೊಡಿ. Is it so difficult? ಒಂದು xerox ಕೊಟ್ರೆ ಆಯ್ತು. One week. Learned counsel for the appellant submits that he would pay the process to issue notice to the unserved respondents during the course of the day. It is made clear that if process is not paid during the course of the day, the appeal against the unserved respondent shall stand dismissed. Yes, ಇವತ್ತು ಕೊಡಿ, ಇವತ್ತು ಕೊಡಿ ಮೇಡಮ್. 4:15 ಒಳಗೆ ಯಾವಾಗಾದ್ರೂ ಕೊಡಿ, ಆಯ್ತು ಇರ್ಲಿ ಮೇಡಮ್. ಇವತ್ತು ಕೊಡಿ, ಪ್ರೋಸೆಸ್ ಜೆರಾಕ್ಸ್ ಕೊಡಿ. 4:45 5 ಗಂಟೆವರೆಗೂ ಬಂದು ಕೊಡಿ. ಯಾರು ಹೇಳಿ? ನೀವು ತಗೊಂಬನ್ನಿ, ನಾನು ಕೊಡಿಸ್ತೀನಿ. ಇದು ಬಿಟ್ರೆ ಇದೇ ತರ ಇನ್ನೊಂದು ವಾರ ಕೊಟ್ರೆ ಅದು ತಿರ್ಗಿ ವಾರನೂ ಅದೇ ಮೇಡಮ್. ಕೊಡಿ. ಎಸ್, ನೋ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್.
Only difficulty is the respondent number, one of the respondents, Rashid Ahmad. I am not representing him in the second matter, and there is a dispute among between the sisters and the brother. That is the one difficulty we are facing. Otherwise, my clients have come.
Alright, but then if one party is not willing,
That is not accessible to me because I have not filed wakalat for it.
therefore is not willing. He is not joining the compromise.
Right now.
ಏನ್ ಮಾಡೋದು?
Ready to pay this. You more than equal share and all authority. This I'm ready to pay out. Only difficulty is
I have spoken to my counterpart. I requested him whether he can persuade that non-appearing party to agree for the compromise. In all possibilities could be done because he will have a.
He will refer it. The learned counsel for the appellant and the respondent.
Except respondent number 3.
For the respondent submits that there are possibilities, clear possibilities of settlement of the dispute. Stop. The learned counsel for the appellant submits that he is willing to pay up the sum of rupees 2,75,000 and that he would withdraw the suit filed in OS number 59 of 2006 from the file of the senior civil judge at Chikmagalur.
49 of 2006 is filed by my client.
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರೆ ಬೇರೆ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ ಹಿಂದೆ ಅದು ನಂಬರ್ ಏನು
62 of 2004, that he has to withdraw.
OS 62 of 2004 on the file of the same court. Same court.
Additional civil judge was filed before the court of the additional civil judge.
On the file of the additional civil judge.
Additional civil judge junior division.
Additional civil judge and junior division and JMFC. Mudigere. Stop. Since one of the respondents is not willing, since one of the respondents has not given adequate instructions to the learned counsel, it is appropriate that this appeal is referred to the mediation center at Chikmagalur for amicable settlement of the dispute. Parties are directed to appear before the mediation center at Chikmagalur on 7th April.
Need to receive at least 25.
Respondents 1.
Respondents 1, 2 and 4 in the RSA number.
1, 2 and 4.
In RSA number
1890 of 2014 are willing to accept the sum of rupees 2,75,000 in settlement of their claims. 7th of April. Office objections in copy ಕೊಟ್ಬಿಡಿ. Learned counsel for the appellant has furnished copies of IA 1 to 3 of 2022 to the learned counsel for the respondent. Hence, office objections raised on IA 1 to 3 of 2022 are complied. Any objection? Since the learned counsel, the learned counsel Sri Somsekhar Kashimat undertakes to appear for the legal representatives of the deceased respondent. Full stop. In view of the full stop, he has no objection to allow these applications. Hence, IA 1 to 3 of 2022 is allowed. The counsel for the appellant is directed to amend the past title and implead the legal representatives of the deceased respondent. Office is directed to show the name of Sri Somsekhar Kashimat as the counsel for the legal representatives of the deceased respondent. This is the appeal for final hearing as per seniority. Amended cast title. ಎರಡರಲ್ಲೂ ಅದೇ ಸೇಮ್ ಆರ್ಡರ್. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರ್ಬೇಕಲ್ವಾ? Office objection. What is this office objection? IA 1 of 20 is filed to recall the order dated 12/12/2019, by which this court dismissed the appeal for non-compliance of office objections. The cause shown for not complying the order dated the office objections is accepted. Hence the order dated 12/12/2019 is recalled. How much time you need? 2 weeks. Take 3 weeks for comply. 3 weeks time is granted to comply the office of failing appeal shall again stand dismissed for non-compliance of office objections without reference to the bench.
Respondent. The order. The matter was they were really capacity. Respects of the draft Mailad, the appellant has been taken. I pray your last proceed for hearing. Admitted. divergent findings. Good filed for declaration and injunction was null decreed. Then appeal filed by the respondent was allowed and suit was dismissed against that fellow.
The appeal is admitted. IA1 of 19. Since the appeal is admitted and pursuant to the order passed by this court. What is the date of the order?
28/11/2018. 28/11/2018.
As per the order of this court dated 28/11/2018, the respondent has, the appellant deposited the proceeds.
Subsequently, accounts had to be written accordingly.
28/11/2018, the appellant has deposited the proceeds of the harvest for the first year and has accounted for the income earned from the same property from the subsequent years. No orders need to be passed on IA1 of 19. This is the appeal for final hearing as per senior.
There are appellates by me. Lord, I seek time till Monday, my lord. There is some office objections with respect to some cost settlement. I shall have it corrected.
This time is granted to comply the office of business.
Monday, much.
2 weeks.
Much. There is some urgency, my lord. There is a mistake, lapse on my part. Kindly
Comply
grant-
ಮಾಡಿ comply ಮಾಡಿ move ಮಾಡಿ.
Much.
2 weeks. What is the suit for?
Since permission is also being granted, the court will be inadequate. While the appeal was filed at 38 to the inadequate court fee was paid and not the past same value of paid by.
But there is some fresh violation slip filed in OS number 150 of 2006. Will you furnish that violation slip? Please furnish that violation slip.
You last to 66 and 38 days.
66 and page number 66. Court fee paid on the appeal is 75 rupees.
That's what I have paid in the arrangement. Court fee was paid up on the gain at 66 rupees. 25 rupees was deficit. That was paid before the grant of subsequent.
Where is that subsequent violation slip? There are 2 violation slips filed. The fresh violation slip is filed in OS number 150 of 2006. Please furnish it. We do not know. 2 weeks time is granted to comply the office of comply madi, you make a mention, I list it. Counsel for the appellant subject that is paid process 3rd of March, office to check, verify and proceed.
My lordship appears for the
Granted to comply the office.
yes, my lord. In objection 1, my lord, the appellant name is Ramaya Chandrasekhar. The actual name of appellant number 2 is Chandraya only, my lordship. They have filed the written statement before the trial court, my lordship. Have signed Chandraya only, my lordship.
On arraying of defendant number 3, Rattamma.
And that one, in
Why Ratnama is not added as a party in this appeal?
it has ex parte, my lordship. Ratnama has
Madam, please add the parties. Please understand. Party should be shown in the cost title, and thereafter you seek whatever you want.
okay, my lordship. Okay. Well,
So shall be complied with a period of 2 weeks. ಆಯ್ತು ಏನು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡಿ ಬರ್ಕೊಡಿ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಬರ್ಕೊಡಿ ಬರ್ಕೊಟ್ರೆ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡು ಓವರ್ ರೂಲ್ ಮಾಡ್ತೀವಿ ಬರ್ಕೊಡಿ ಎಸ್ ಲಿಸ್ಟ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸರ್ ಎಸ್ ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ ನೇಮ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಶ್ರೀಧರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಮುಂಚೆನೆ ಇಷ್ಟೊಂದು ಹೇಳ್ತೀರ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಗೋವಿಂದರಾಜು ಗಂಗರಾಜು ವ್ಯತ್ಯಾಸ ಇದೆಯಲ್ಲ How can Govindraju and Gangaraju be the same? But you appeal ಹಾಕಿರೋದ್ರಲ್ಲೇ ಗೋವಿಂದರಾಜು ಅಂತ ತೋರಿಸ್ತಾರೆ ಟ್ರಯಲ್ ಕೊಟ್ಟು ಗೋವಿಂದರಾಜು ಅಂತ ತೋರಿಸ್ತಾರೆ Mister, you know your name, correct? Govindraju knows what his name is. How can Govindraju become Gangaraju? ನಿಮ್ಮ ಹೆಸರು ನೀವೇ ತಪ್ಪಾಗಿ ಹೇಳ್ತೀರಾ ನಿಮ್ಮ ಹೆಸರು ನೀವು ತಪ್ಪಾಗಿ ಹೇಳ್ತೀರಾ This appeal is filed by Boraya by LRs. So Boraya was the defendant, correct? ಗೋವಿಂದರಾಜು ಪಾರ್ಟಿ ಮಾಡುದು ಗೋವಿಂದರಾಜು ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಯಾಕೆ ಕರೆಕ್ಷನ್ ಮಾಡಿಸ್ಕೊಂಡಿಲ್ಲ ಅಲ್ಲಿ ಯು ಶುಡ್ ಗಾಟ್ ಇಟ್ ಕರೆಕ್ಟೆಡ್ ಮಿಸ್ಟರ್ ನಿಮ್ ಸಂಬಡಿ ಕಾಲ್ಸ್ ಗೋವಿಂದರಾಜು ನೀವು ಬೆಂತಿರ್ಗಿ ನೋಡ್ತೀರಾ ಇಲ್ವಲ್ಲ ಗಂಗರಾಜು ಅಂತ ಹೇಳಿದ್ರೆ ನೋಡು ವೈ ಡಿಡ್ ಯು ನಾಟ್ ಗೆಟ್ ಇಟ್ ಕರೆಕ್ಟೆಡ್ ಎಸ್ ಪ್ಲೀಸ್ ಗೆಟ್ ಇಟ್ ಕರೆಕ್ಟೆಡ್ ಫ್ರಮ್ ದ ಟ್ರಯಲ್ counsel for the appellant that the name of appellant number 4 wrongly shown as Govindaraju instead of Gangaraju. So it is seen from the trial court, it is seen from the judgment and decree of the trial court that the name of the appellant number 4 was shown as Govindaraju. Likewise, in the appeal filed before the first appellate court, his name is shown as Govindaraju and not Gangaraju. That way of the matter, counsel for the appellant is directed to get his name corrected in the cost title of the trial court and the first appellate. Yes. Yes. 2020 appeal, we are in 2022. You still say there is urgency. 2 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತಿದ್ದು ಇವಾಗ ಬಂದ್ರೆ ಮಾಡಿ No, first to get it corrected. Sorry. See, what happens is, please understand. You nimda allow madidre anta itkoli. Allow madidre, tomorrow the other side will say that Gangaraju is somebody else, Govindraju is somebody else. What will you say? Please get it corrected. Sorry. Trial court ಎರಡು ಕಡೆ correction ಮಾಡಿಸ್ಕೊಂಡು next. 2 weeks time is granted to compare. Same on. Yaru Hemavati. Yes. Now what is this, madam? Non-arraying of respondent number 4, Hemavati in RSA.
has been shown as Hemavati matter. Hemavati is not at all connected with this matter. And they have filed an application under section 151 of CGC mirror. First of all, it where it has been allowed and it has been removed as part of it. But still, in prior for judgment and they show the name of the
High Court decree Lily the Hemavati.
first of all. First of all. Say that.
Hemavati is not a person who is interested.
No, connected. What has happened is Respondent number 1 has there will be the course of the prevention of RNA. There they have filed a amended memo, including Hemavati, who is no longer concerned. Again, they have filed application under section 151, and that has been allowed. And Hemavati's name is removed, and amended appeal memo is also filed.
Where is that? Yes, where is this, madam? Really there? Office objection is kept open. This is the appeal for admission. We'll consider it later. This is the appeal for admission. 2 weeks.
Melod in 19 I have.
Pardon?
Melod serial number 19, Melod.
2 weeks time granted to comply the office objections.
Melod, there is some urgency in this matter. It's a suit for recovery, Melod. What they have done is, during the last week, Melod, they have moved the court and they have moved the attachment of the land. It's a suit for recovery.
So please comply the office objections. We'll list it immediately after you comply.
Almost tell once note, but some submissions to birth kotidive. Last time, my lord, I mentioned this matter twice before your lordship's pleading the urgency.
But Mr. Why don't you comply the office objections you mentioned, but you don't comply? Comply today itself. I'll list it tomorrow.
All right, that observation may be my lord. I'll comply. Some urgency is there because they are attaching the
complaints of office objections. Office is that list the appeal immediately after complaints of office objections.
Lord, I appear for the appellant in this matter. Lord, the first office objection is that, Lord, I have submitted this, my lord, regarding the office objection. The first office objection is this is Mallikarjunaiah is the name, but in the original suit, he was named as Mallikaiah, one of the LRs of defendant number 1. And that, but in the appeal, he had filed the appeal. He's also one of the appellants in the RA. He's named himself as Mallikarjunaiah. So I have adopted the same name.
The office objections raised regarding. But what is the actual name, madam? Because the
Mallikarjunaiah, my lord, because in the appeal. Mallikaiah, see, Mallikaiah is son of late Sharadamma. Sharadamma is the LR of CL Lingaiah, who was the
Mallikaiah in this Mallikaya in before the trial court is aged 30 years.
Yes, my lord.
Mallikarjunaya in the appeal is aged 52 years.
My lord, there the plaintiff, who is the respondent number 1 here, has arranged these people as parties in the trial court, my lord. That is how the LR application came to be filed, and that's how the cause title was there. But however, appeal has been filed by Mallikarjunaya as the legal representative of late Chardamma, and also as appellant number 6 clause 6 clause 3.
Submits that the name of the appellant number 1 herein was wrongly shown as Mallikaya before the trial court. The office objection raised regarding discrepancy in the name of the appellant is ruled. You have the explanation offered. What about this non-arraying of defendant number 156 of OS?
My lord, I have also mentioned in the note to the cause title, my lord, your lordship may kindly turn to page number 8, because this is how they had filed the regular appeal, my lord, and they also given the same reasoning.
156 of the original suit.
Yes, defendant number 1 was the sole defendant. He died, and his LRs came to be brought on record that they are defendants number 2 to 7, my lord. And defendant number 8 was subsequently arrayed as a party because she has sold the property to defendant number 1. Your lordship may kind.
Implead everybody. Please implead everybody. Everybody should be shown in the costal. You seek for dispensation of notice. You do whatever you want. But in the costal, everybody should be shown.
My lord, in the regular appeal, they were not shown, my lord. The cause title of the judgment.
Now you please show, madam. Now you work torsi.
I'll make
regular
this
appeal. Regular appeal is filed by you.
Yes, my lord. My lord, they are dead, my lord. No, they are dead. I can't make a dead person, array a dead person as a party, my lord.
Or who is dead?
Your lordship may kindly turn to page number 8. I have made this note, my lord. Defendant number 1 died and his LRs came on record. His LRs are here, my lord. Defendant number 5, who was also LR of defendant number 1, suit against her was dismissed by court order dated 28/4/2008. She had also died. Then defendant number 7 died.
Wait, Lingamma is alive or dead?
Lingappa, my lord. Lingappa is dead.
Lingamma, first heir of the defendant.
First heir of the defendant, Lingamma, my lord.
She is dead or alive?
Lingamma is not alive, my lord. Lord, Lingamma is the wife of Lingappa. She is not being made party, my lord. She's not alive, my lord.
Is Lingamma dead or alive?
My lord, I died, my lord, and was not made parties to the
appellate. Memo to that effect. Please file a memo to that effect.
My lord, I have made it in the note, my lord. The same note was accepted in the regular appeal, my lord. Whatever is the cause title in the regular appeal, I have followed the cause title here. And this was the note that was given in to the petition, my lord, to the regular appeal in the appeal memo.
What is it to show that Lingamma is dead? Have you mentioned that Lingamma is dead? Lakshmi Devamma
died and
a suit against her dismissed. Sharadamma.
Sharadamma died and the LRs are already on record, my lord. They are appellants number 1.
Put this Lingamma, file a memo to that effect.
I will file a memo, my lord.
Counsel for the appellant submits that the defendant number 5 and defendant number 6 had expired.
No, defendant number 6 LRs are on record, my lord. They are the appellants who are pursuing.
Therefore, they are dead, isn't it?
Defendant number 6, my lord.
That is what I stated. Defendant numbers 5 and 6 are dead.
Yes.
And the LRs of defendant number 6 is already on record.
Yes, my lord.
And defendant number 1 also died. And
yes,
that counsel could file necessary memo indicating the death of the defendant number 1, Srimati Lingamma.
I'll file all the. Yes, my lord. I will file a memo.
She's raised or overruled. The appeal for admission.
Much obliged. Thank you, my lord.
IA 1 of 22 is allowed. This is the appeal for final hearing as per seniority. Same order. Same order. Huh? ಬರ್ಲಿ ನಿಧಾನಕ್ಕೆ 2016 ಹಿಯರಿಂಗ್ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ ಹೋಗಿದೆಯಾ ಇಲ್ವಾ ಏನಾಯ್ತು ನೋಟಿಸ್ ಶುರುವಾಗಿದೆಯಾ ಇಲ್ವಾ ರೆಸ್ಪಾಂಡ್ ಡೇಟ್ ರೀ ಅದಕ್ಕೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ ಇಲ್ವಾ ನೋಟಿಸ್ ಆನ್ IA 123 of 2021 ಹೋಗಿದ್ಯಾ ಏನಾಯ್ತು ಹೋಗಿದ್ಯಾ ವಾಪಸ್ ಬಂದಿದ್ಯಾ filing the appeal. This is filing the appeal. Delay in filing the appeal condone ಆಗಿದೆ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ ನೋಟಿಸ್ ಏನಾಗಿದೆ ಶುರುವಾಗಿದೆ The notice issued to the legal representatives of the respondent number 182D is served and Shri M.R. Hiremathad has made appearance for the respondents 182D. There is no objections to this application. There is no objections to this application. Hence IA 123 of 2021 are allowed. The counsel for the appellant is directed to amend the cost title and impede the legal representative of this is R1. Is the appeal for admission?
Appearing for first respondent, my lord.
Permission filed by the counsel for the appeal. What is
Like copy has not been served. Copy of IA 1 of 2022 has not been served to the respondent, my lord. Since my specific defense before this honorable court itself is that, my lord, the appeal itself is not maintainable. Since the appellants are the defendants before the trial court. As against the findings of the judgment and decree of the trial court, my lord, they have not preferred any appeal before the first appellate court. For the first time, my lord, the second appeal has been filed before this honorable court.
Copy has been
Will has not been proved before the trial court.
But what is this IA 1 of 22 for permission? Is it listed for admission or not?
Appeal is already admitted.
Let it come for hearing. IA 1 of 22.
Copy has not been served, my lord.
ಯಾವುದು IA 1 of 22 ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ನೀವೆಲ್ಲ ಕಳೆದಾಕಿದ್ರೆ
ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ
ಈಗ ಕಾಪಿ ಬೇಕು ಅಂತ ಕೇಳಿ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ ಸೀಲು ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಇದೆ ಆಫೀಸ್ದು
ಪ್ಲೀಸ್
somebody has received it from your office.
Please, my lord.
IA 1 of 22 shall be considered along with the name. This the appeal for final hearing as per seniority. Any date you togoli, but it will not reach. List on 10th as desired by the 11th council for that. 11th. Issue notice on IA 2 of 21. IA 1 of issue notice on IA 1 of 22. The copy sir ಇಲ್ಲೇ ಇದ್ದಾಗ ಇಂಜಂಕ್ಷನ್ ಹೆಂಗ್ ಕೊಡೋದು ಹೇಳಿ ಇಲ್ಲೇ ಇದ್ದಾಗ ಇಂಜೆಕ್ಷನ್ ಕೊಡ್ಬೋದಾ ಹೇಳಿ ಕೊಡ್ಬೋದಂದ್ರೆ ಕೊಡ್ತೀನಿ ಏನ್ ಮಾಡ್ತೀರ ಕರೆಕ್ಟ್ ನೀವು ಇಷ್ಟ ದಿನ ಏನ್ ಮಾಡ್ತಿದ್ರಿ 1247 ದಿನ ಏನ್ ಮಾಡ್ತೀರಿ 3 ವರ್ಷ 25 100 ವಾಟ್ ವರ್ ಯು ಡೂಯಿಂಗ್ ಫಾರ್ so many days ಹೊಡೆದೋಗಿದ್ ನೋಡಿ ಅಲ್ಲೇ ಇದು ನೋಡ್ಯಾಕೆ ಎಷ್ಟು ದಿನ ಬೇಕು? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಯಾವತ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ, ಯಾವ ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀರಿ ಹೇಳಿ ಅವತ್ತ. ಸಾರಿ, ಇಲ್ಲೇ ಇದ್ದಾಗ ವಿ ಆರ್ ನಾಟ್ ಸಪೋಸ್ ಟು ವೆಸ್ಟ್. ಯಾವತ್ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀರಿ ಹೇಳಿ? ನಾಳೆ ಹಾಕ್ತೀನಿ, ನಾಳೆ ಹಾಕ್ತೀನಿ. ಇವತ್ತು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನಾಳೆಗೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಹೇಳಿ ಯಾವತ್ತು. Issue notice on IA 1022 list on Friday. If the appellate counsel for the appellant is able to serve copies of the appeal memorandum to the respondent before that, yes. Lega.
Finally, proceedings and the latter of the process of the first finally, proceedings of the person has
ಏನಾಗಿದೆ ಹೇಳಿದ್ದು ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್.
finally, proceedings finally, proceedings the person. He has been found.
Who is the dead person?
Dead person is mother of the appellant. She was the first appellant. She was the first plaintiff.
FDP, who is the dead person? Harijana Nagaraju. FDP petitioner.
Number 842. FDP has been challenged in the appeal.
Now, Mr. Who is dead?
First was the
Yesterday. So she is the petitioner before the final decree.
Yes.
And respondent number 1.
Yes.
Right. So,
she was expert prior to the interest to the she has been granted. Again, minutes finally. Even final decree also runs the first respondent, that is dead person has been granted. Again, the appeal has been deferred. So, without giving an opportunity and dead person, he has been found. But again, the trial court has considered.
No, we are not on that. Harijana Nanji was the defendant. Correct? Correct or not? You are the plaintiff. Harijana Nanji was the plaintiff. First plaintiff. They filed a suit.
Along with the daughter's suit has been filed for partition and separated.
Correct? Suit is decreed.
Suit is decreed and partition and share has been filed.
Harijana Nanji's children are already on record. So there is a question of abatement. In spite of that, after the victim has been masked again, the pilot she is the first petitioner in the pilot. Whoever is dead, mister.
Again, the court has said it is a mistake and
Obviously.
But no opportunity is being given automatically. It's the share after the death of the share has to be sister and son. Sister and share has to be reduced. And then now reason is yes, just accept. That's already informed. That's how settlement is going. Otherwise, recent second has come. Nothing part. First, already
ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿನ ಬಂದ್ರೆ ಇನ್ನೊಬ್ರು ಸತ್ತೋಗ್ತಾರೆ. Then your objective will be achieved. So when do you want? If you allow this appeal to remain, ಅವರು ಸತ್ತೋಗ್ತಾರೆ. ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್ ಅವ್ರು ತೀರೋದು, ನಿಮ್ ತಾಯಿ ತೀರೋದ್ರು, ಒಬ್ಬರು ತೀರೋದ್ರು, ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ. ಅವರು ತೀರೋದ್ರೆ ನಿಮ್ದು adjournment ನಿವೇದನೆ ಮಾಡ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡು. At the request of the learned counsel for the appellant on 12th April as a last chance, it is made clear that if by the next date the parties do not report the settlement, the appeal shall be taken up for disposal on merits. Yes. Yes, what settlement?
Lord, can we see the last order, Lord? 22/4/2021. They submitted the same thing. There is no settlement between the parties.
So, Mr. Please listen to this order. Please bear with me. This court had granted an interim order so as to enable the parties to arrive at a settlement. This is in 22/4/2021, 1 year back. It is noticed the counsel for the appellant has taken adjournment. Even today, counsel for the appellant seeks time on the ground that CH Devendrappa is indisposed. Hence, list this appeal after summer vacation 2021. It is made clear that if the appellants do not argue this appeal or report a settlement on the next date of hearing, interim order shall stand vacated. Sorry, no further adjournment. We'll vacate the interim order. Do whatever you want. You are either argue today. The interim order kotti settlement ಮಾಡ್ತೀನಿ. Sorry. Recall. This court had noticed on 22/4/2021 that the appeal that no further adjournment shall be granted and that the interim order shall stand vacated. Even today, the learned counsel for the appellant is not ready to address arguments on the appeal. Hence, the interim order granted on what date? 12th March 2021 is vacated. The final decree, vacated, full stop. The final decree report is at liberty to proceed with the drawing up of final decree. CP2. Fatal accidents ಇದಕ್ಕೆ ಏನು ಸಂಬಂಧ? Motor vehicle. No, Mr. Indian Fatal Accidents Act. ಅದಕ್ಕೆ ಅಪ್ಲೈ ಆಗಿದೆ ಯಾವುದಕ್ಕೆ? ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಅಪ್ಲೈ ಆಗೋದು. Correct. Electrocution Act ಇಲ್ವಾ? Huh? Where is that act? Indian? No, where is that Indian Fatal Accidents Act 1855? Yeah. The ground, huh?
They have paid the compensation of 1 lakh at the time of accident. That was not paid at the Honorable Court. The division bench of the Honorable Court paid that amount. But as a compensation.
So where is this 1 lakh input? Where is the reference to that?
There is a organization. The sum of is 1 lakh.
Paragraph number?
One lakh.
Trial court judgment. There's no necessity to deduct the same antara.
But the division bench of the Honorable Court and direct the amount and the has to be deducted.
This should be a deposit amount. ಇಲ್ಲಿ ಎಷ್ಟು ಫುಲ್ ಮಾಡಿದೀರಾ? What has happened to the amount? Use ಆಗಿದೆಯಾ? Full. The learned counsel for the appellant submits that representing compliance with the direction, the compliance with judgment and decree of the trial court. Like 12,000 is already deposited before the trial. Stop. Submits that the sum of which 1 lakh was paid as interim compensation, and which the trial court has refused to deduct. Stop. He also submits that the claim ought to have been filed within 1 year, 2 years from the date of death of the person. But in the present case, the suit was filed after 2 years. Stop. In view of the above, the substantial question of law arises for consideration. Whether the trial court and the first appellate court committed in error in not deducting sum of which 1 lakh paid as interim compensation to the plaintiffs. Whether the suit was barred under Article 82 of the limited paper books within that were filed within. Filing of paper books is dispensed with the appeal for final
appear for the appellants in this case, lost. Now, this is covered by Vinit Sharma case loss. The trial court initially decreased the suit in favor of the petitioner. The first appellate court holding that the father was not alive as on the date of this act came. Filling a Prakash case.
My lord, carved out an exception that if at all a unregistered partition is also acted upon, there are sufficient.
What is there to show that unregistered
parties have been indicated on the basis of written
How have you proved that unregistered partition?
That is not seriously disputed by the other side.
Not even in unregistered partition, we are in the parties.
TW5, witness my lord, whom I have examined, to show that there was a panchayat. And even prior to the commencement of the Amendment Act itself, the parties my lord have been put effect. And specifically by the order of the Tahsildar based on the paragraph.
So what is the evidence in the form of how the property has been cultivated, how they have treated it? Otherwise, an idea.
The fact that we have entered into this partition is very documented. And also,
Where is the document? The document there.
Exhibit D2 is the document.
D2.
May I tell you not? Exhibit D2 is between the first wife, son, and another not son. And these daughters and mothers, they have been not been made party.
Where is the family tree? Family tree is
But family tree is not produced.
It's produced, Mr. 74. Number 70. Partition is between whom?
Partition is between my lord Lakshmamma, Nanjunde Gowda and Nanje Gowda. Nanje Gowda is the husband of my client.
Lakshmamma, then?
Nanjunde Gowda and Nanje Gowda. The male members of the family along with the mother.
What about this Range Gowda?
Range Gowda, my lord, is the son from the first wife of Uche Gowda.
He's not married.
My lord, he has.
But the first defendant is the mother. Second defendant is another brother. And 4 to 6 are the sisters. These persons are not made parties to that partition deed.
You are not necessary parties at that point in time. What about Uche Gowda? Some share must have been allotted to the female heirs under section 6.
And this was prior to the commencement of the act.
Even if it is prior to the commencement of the act, then section 6 will apply.
But the fact remains that 2 persons might not have come together and they have.
Right. Even before the Amendment Act of 2005, the female heirs are entitled to share. Otherwise,
Notional partition.
Then the partition has no value at all.
To that extent, my lord, they may be entitled. The entire thing cannot be set because there is a harmony, my lord, as far as the other 4 persons are concerned.
ಅದಕ್ಕೆ settlement ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳೋದು. Yes.
I am a widow, my lord. I do not have any other property. They are all, only one daughter has come before the court.
Therefore, you should settle it. If you want harmony to prevail in the family, you should settle it.
And Auribru Bandila, Lakshmamma and Nanjunde Gowda, they have remained expert. They are not represented in this case. They are all beneficiaries under the partition. Elder Putpon Mandadru, some properties could be given. Everything.
Are they willing for a settlement?
No, so I will instruct my clients. Not this is from Chandrai Patna. Lordship may fix a date. I will direct them to appear before there or some mediation center. Let them sit and settle.
Refer to mediation center. For counsel for the appellant and the respondent subjects of the dispute could be referred for mediation. So, in view of the above, command of the parties are directed to appear before the mediation center at Chandrai Patna, the Lydia. Chandrai Patna on
Next week, any date most.
5th of April.
Please.
Yes.
For the respondent.
Yes.
Appear for the respondent.
Yes, Mr. Undeka Ishwar, but Anucha Talpoli. Yes.
Aye.
This is the admitted fact that the appellate is the owner of the land. It is being a committee. The temple is done here. The land belongs to the temple is undisputed fact.
At once, my lord, the members of the appellate also, my lord, the members of the dependent India Trust. But for the purpose of running the education institution, land was not given as a license. Now the airport, the school has been filed by the respondent dependent. Saying, the intention has to be considered, there should be declaration. That has been rejected. And my counterclaim that, I am the owner. The appellant is the owner has been agreed. And, consequently, eviction order is also passed. The lower appellate court, partially reversed to the finding of the airport, saying, it is a lease and it is mandatory to issue a notice and then only can await the person who is.
Where is the finding of the first appellate court?
Warrant para 37 on page 42 of the lower appellate court. 42. Is that there is no written contract?
Just wait. Para 42.
Page 42. Para 37. It is just clear that there is no written contract of peace related to the use of this property. It is also clear that the school building is situated in either number 3 and 4 of the school schedule property. Item 1 and 2 of the school property is used as a playground for the school children, and there is no place for water tank and electric belonging to the school within the area. So there is no the resolution containing executive produced by the can be looked into for the collateral purpose, for the purpose of proving possession of the building as a lessee of the social properties. Thus, the evidence on record established that the building is possession and enjoyment of item 1 and 2 of the social properties as a lessee under the dependent. But the D3 is only in the nature of the license or temporary purpose. It has been even marked as the instance of the defendant. It has not to do with any document. In this case, is that there was one panchayat, and in that panchayat, in the police station, some document has been.
Please read para 30.
The next question to be considered is as to whether the issuance of notice of guilty by the defendant as required under section 106 of Transfer of Property Act is necessary. The content of the plaintiff that the lease is to be terminated by issuance of the notice as required under 106 of the Transfer of Property Act, and since the defendant has not issued any such notice before delivering the counterclaim, the relief of eviction of plaintiff to be scheduled properties cannot be granted. On the other hand, it is a contention of the defendant that no notice is necessary pursuant to the amendment to section 106 of the Transfer of Property 2003 and the act of filing the suit claiming possession itself will amount to a notice for the. But now the issue is not either whether it is a license or lease. Since
What is the property which was licensed?
The property is not at that point of view, because when where the building is situated from the defendant. Now, at one point of time, the members of both and defendant are same, except one person. Now, the temple want to do the temple activities during the premises. They want to keep the defendant. Therefore, they so even assuming it is lease, by efflux of time, under section 111.
What is there to show that it's lease? What is there to show that it's a license?
Exhibit D3 is relied upon because
where is that?
Page 47 of the lower court, OS 150. Internal page. Para 23 onwards. As already discussed before, the plaintiff trust has not produced any document to show that the trustees of the plaintiff trust have requested the defendants of suitable properties from lease to run the school by the plaintiff trust. OPW1 reports that there is a resolution from the plaintiff trust which shows that they have requested the defendants of to give suitable properties on lease, but
or reason best known to them, they have not put the bill. Then it was suggested to him that whether the plaintiff had any impediment to produce the same, he proposed that there is no necessity to produce the same. In spite of that, not produced. Exhibit B3 is the resolution of the defendant committee for the year from 1948, where Exhibit D 3D at page 163 is the proceedings dated 12/1/1990, where at para 3 it is that the subcommittee was formed and this is subcommittee consists of so and it is also seen that was formed for the purpose of development of vacant land of the temple and also construct one school building and Kalyana Mandapa and also to look after the management of the that work is said the subcommittee has been formed. So it is very clear that the property of the temple there was no school building as on 12/1/1990 and it was also admitted by the that as on 12/1/1990 there was no school building and it is admitted by BW that the was
Yes, Mr. Pundika Ishwar Bhatt. Ishwar Bhatt. Pundika Ishwar Bhatt. Not necessary.
2011 SCC 70. It's a time not the notice is not.
Pundika Ishwar Bhatt. Yes, please.
Please. Please.
You stop pulling out cash from your pocket. Yes, Mr. Pundika Ishwar Bhatt. Percol. Whether the admit
Smell. My lord,
yes.
You know, the first appellate court has rightly held that they have not issued notice for termination of tenancy. It is the finding of the both the courts that we have been, that is the plaintiffs are the tenants under the defendant. That is admitted fact because it is based on the oral lease. And therefore, under section 106 of the TP Act, it is mandated to issue notice for quit notice to the tenant. That is not being done. No document was produced and admittedly no notice, quit notice was issued. Therefore, such relief could not be granted, though they have sought in the counterclaim that suit for that is the relief of possession. Because without quit notice, it can't be granted. That is the finding of the first appellate court at para number 48, my lord. May take your lordship to para number 48. And in answering the same, in the point number 3, the first appellate court has rightly held that so when the quit notice is not issued, the relief of possession cannot be granted. Therefore, the finding of the trial court was rightly reversed by the first appellate court. Therefore, their appeal, if they want, they have to file a fresh suit by issuing notice, quit notice to me, and then I will get an opportunity to meet their demand. Therefore, the finding of the partition does not
make
call
sense for you to issue a notice and then I think you keep it, you keep this appeal pending for the next 10 years. Instead of that, why don't you file a suit for and recover possession?
The same party, same litigation, pending before the trial of 2000. Thereafter, the lower now, once again, one more round of litigation. Lower court is not justified, not demanded. The party.
Suppose if we say that quit notice is required, if it is construed.
Notice is not required. That is why I just pointed out that judgment.
Yes.
The recent judgment of the apex by reflex of time. The fees will not be given. There is no necessity for issuance of
Aspect, call for records. Substantial questions of law which arise for consideration in appeal are: number one, whether the defendant was required to issue a notice of termination under section 106 of the Transfer of Property Act, or whether the defendant could sue for eviction of the plaintiff in view of section 111G of the A of the Transfer of Property Act. Number two, whether exhibit B3 was a lease or license. If it was a question mark, if it was a license, whether the defendant was required to comply with section 106 of the Transfer of Property Act. Paper books to be filed within 8 weeks. Increasing stay of all for increasing stay of disposition. Disposition involved. Partition maintain status quo with respect to the property interest. Oh, sorry. What is what?
What is the
Party shall maintain
what is the interim order granted?
status quo.
What my lord, the cash finance.
What is? ಏನಾಗುತ್ತೆ ಇವಾಗ ಸಂಬಂಧಿಕರಲ್ವಾ? ಏನ್ ಮಾಡೋದು? ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಏನಂತ ಆಗಿದೆ ಇದು?
5 ಲಕ್ಷ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಹಂಗಾಗಿ 5 ಲಕ್ಷ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಇದು ವಾಸ್ ಟೇಕಿಂಗ್ ಕೇರ್ ಆಫ್ ಅವರ್ ಫಾದರ್ ಅಷ್ಟೇ. ಬಿಕಾಸ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಎನಿ.
ತಗೊಳ್ಳಿ ಸಾಕು ಆಯ್ತು. ಏನೋ ಮಾಡಿದ್ದೀರಾ, ಕಷ್ಟಪಟ್ಟು ಏನೋ ಅವ್ರನ್ನ ನೋಡ್ಕೊಂಡಿದ್ದೀರಾ, ಏನ್ ಮಾಡ್ತೀರಿ? ಒಳ್ಳೆತನ ಅವರು ನಿಮ್ಮನ್ನ ಪೂಜೆ ಮಾಡ್ತಾರೆ, ಗೌರವವಾಗಿ ನೋಡ್ಕೋತಾರೆ ನಿಮ್ನ. ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನೋಡ್ಕೊಂಡಿರೋದಕ್ಕೋಸ್ಕರ ಜಮೀನ್ ಕೊಡಕ್ಕಾಗತ್ತೆ ಸ್ವಾಮಿ? ಹೇಳಿ ಹೋಗಿ. ಅವ್ರಿಗೂ ಮಕ್ಳಿದಾರಲ್ವ? ಅವ್ರ ಅಪ್ಪ ನೀವು ನೋಡ್ಕೊಂಡಿದ್ರಿ, ಇಲ್ಲ ಅಂತ ಅಲ್ಲ. ಹಾಗಂತ ಜಮೀನ್ ಬಿಡಕ್ ಆಗ್ತದ? ಹೇಳ್ರಿ ತಗೊಳ್ಳಿ. 5 ಲಕ್ಷ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಿ. ತಗೊಳ್ಳಿ 5 ಲಕ್ಷ ತಗೊಳ್ಳಿ. ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ, ಜಮೀನು ಬಿಡಕ್ ಆಗಲ್ಲ. ಹಂಗೆ ಅದು ಅವ್ರ ಅಪ್ಪನ ಆಸ್ತಿ. ಅದು ಅವ್ರ ಅಪ್ಪನ ಆಸ್ತಿ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬರುತ್ತೆ ಹೇಳ್ರಿ? ಮಾಡಿದ್ರಿ ಸರಿ, ಅವ್ರ ಅಪ್ಪನ ಆಸ್ತಿ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬರ್ತದೆ? ಮಗಳಿದಾಳಲ್ಲ, ಆಯ್ತು. ಒಪ್ಕೋತೀರಾ ಇಲ್ವಾ? ನೋಡ್ರಿ, ಕೇಸ್ ನಡೆಸಿದ್ರೆ ನಿಮ್ಗೇನು ಸಿಗೋದಿಲ್ಲ. ನೀವು ನಡೆಸ್ತೀರಿ ಏನಾಗಿ ನೀವು ವಕೀಲರಿಗೆ ಹೇಳಿ, ವಾದ ಮಾಡಕ್ ಹೇಳಿ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ. ಏನೋ ಬಂದಿದ್ ತಗೊಳ್ಳಿ, ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ. ಕೆಲವೊಂದ್ಸತಿ ಜಮೀನುಗಳು ಕೊಡಲ್ಲ, ಹಂಗಾಗಲ್ಲ. ಹಂಗೆ ಕಾನೂನು ತಪ್ಪು ಬರ್ದಂಗ ಆಗ್ತದೆ. ನಿಮ್ಗೊಬ್ರಿಗೋಸ್ಕರ ಕಾನೂನು ತಪ್ಪು ಬರೆಯಕ್ಕಾಗಲ್ಲ. ನಿಮ್ಮೊಬ್ರಿಗೋಸ್ಕರ ಕಾನೂನ ತಪ್ಪಾಗಿ ಬರೆಯಕ್ಕಾಗಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. ಕ್ಯಾಶ್ ತಗೊಳ್ತೀರಾ? ಹೇಳ್ರಿ ಬ್ಯಾಡದಿದ್ರೆ ಹೇಳ್ರಿ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ. ಕೊಡದೇ ಇಲ್ಲ ಅಂತಿದ್ರು ಒಂದು ಪೈಸಾನು. ಎಸ್ ಬೇಡವಾ ನಿಮ್ಗೆ? ಜಾಯಿಂಟ್ ಏನೋ ಫೈಲ್ ಮಾಡ್ರಿ, ಫೈಲ್ ಮಾಡಿ. ಯಾವಾಗ? Learned counsel for the respondent. Learned counsel for the respondent has paid a sum of rupees 5 lakhs to the appellant towards settlement of the dispute. Stop. ಇವತ್ತು ಮಾಡಿ ಹೆಂಗು ಬಂದಿದ್ರಲ್ಲ ಏನಂತ?
He has to file a memo saying that I have received so much amount.
ಆಯ್ತು, ಇವತ್ತು ಫೈಲ್ ಮಾಡ್ಬಿಡಿ. ದುಡ್ಡು ಕೊಡ್ತಿದ್ರೆ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗೋದಲ್ವ ಸರ್? ನಾಡಿದ್ದು ಆಚೆ ನಡೀತಿ. ಅನ್ಸರ್ಟಿನಿಟೀಸ್ ಇನ್ ಲೈಫ್ ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಅನ್ಸರ್ಟಿನಿಟೀಸ್ ಅರ್ಥ ಆಗುತ್ತಲ್ಲ ನಿಮಗೆ? ಪಾಸ್ವರ್ಡ್ ದುಡ್ಡು ವಾಪಸ್ ಇಸ್ಕೊಂಬಿಡಿ. ನೀವು ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ, ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ. ಮೆಮೋ ಫೈಲ್ ಮಾಡಿ ಇಸ್ಕೊಳ್ಳಿ. Counsel for the appellant submit the appellant is expired list after the case. Yes. The suit is for what? Yes. On what basis?
Villagers have told that it is Vidikar name and we sold it. Conservation. Father's name of the entity is also Uttarakhand to be given in conservation. It is admitted in the evidence.
So who is this Guttaya?
Guttaya is Guttapa is the father of the name. Even the first defendant is also Guttapa. Guttaya, father of the name.
Did the first,
Property has sold to.
at the first appellate court, why it was reversed?
Found that the father not served in lifetime.
Please read from the order. What?
That line. However, Mustafa, father of the benefit to the five who is who has got his brother sister has not discovered anything about doing it like that. As for since from 1966 to 2003, properties are starting in the name of the father of the plaintiff. How can you know that?
How is the father of the plaintiff related to the defendants?
Defendant, first defendant is the father and the oral partition is taken place. Separately, that is also told. The property has been orally partitioned among them. This is the property falling to the father. But the RTC and
So notice call for records. Party shall maintain status with respect to the property till the next date of hearing.
Identified the suit for declaration and constitution of the release of remaindment. The tribunal has dismissed their suit. The lower appellate court is this suit. Hence, defendants are before the law.
Yes. Why was it dismissed?
The trial court dismissed the suit on the ground that the suit schedule property is not valid with respect to the title deed. The plaintiff brought the suit on the exhibit into the sale deed in her father's name. And even the very interesting point is the lower appellate court at paragraph 14 of the judgment at least except western side of the boundary, other three sides are not valid.
Please read that.
That is paragraph 14 of the judgment.
Is true except western side boundary.
Keeping in view of the rival condition of both the parties and findings recorded by the trial court, now I have to pursue the exhibit P2 CLD. Exhibit P2 is the certificate copy of the CLD said to have been executed by Bhairappa Sanam Kapapa, resident of Hosur village.
ಕೆಲಸ ಆಗತ್ತೆ ಇದರಲ್ಲಿ ಹೌದು
Tenancy village had purchased unable 30 gunas in 7 number 47 situated at Ramchandra Hosur village. In this exhibit P2, the boundaries shown as leased by land of Bhairappa, west by Yenamti land, north land of Bhairappa and south by land of Bhairappa. At the same time, I have also produced the plain schedule.
Yes, Mr. Alesha. Have you disputed the boundaries?
This is total extent is 6 acres.
Have you disputed the boundaries in the written statement?
They have not disputed. But even finding of the first appellate court is Malad, even the lot of opportunities are provided to them. They have not provided any single document and they have not sent any evidence, lead the evidence to disprove the boundaries of this.
Please wait. The suit is for declaration. Injunction. Based on a title deed. Correct?
Yes.
Whether the boundaries mentioned in the title deed tallies with the boundaries mentioned in the suit schedule. If not, how you have proved that the suit schedule property exists?
Para 18 of the suit, Malad. Para 18 of the trial court judgment. The plaintiff has failed to prove her title. And plaintiff for the suit schedule property as on the date of filing of the suit. It is true that the sale deed is in favor of the 1960. and there are many changes occurred in the schedule. But the plaintiff who seeks leave of declaration has to prove her case in the proper way. That this is very clearly shows that 1962 judgment said it. 1962 till this date, my lord. Lot of many changes has.
Who has to say the changes?
That is the only thing, my lord. That is in between whatever the transaction changes has taken place. That is not treated and shown.
If there are changes, who should say that?
Plaintiff.
If the plaintiff doesn't say that, how will the court know?
But my lord, this land is as stated by the pleading and my lord, this said it is not one and the same. It is different land. This is to disprove the claim of the plaintiff. They know there is nothing in, even they are not stated lead any evidence.
Our written statement file madilla anta itroona. Let us assume that they are not filed the written statement. You have come to the court based on the sale deed.
Yes.
How you have proved the boundaries is what I am asking. How you have proved the boundary? Forget their statement. Forget their defense. Even if there is no written statement, an automatic decree will not
It's
result.
duty of the plaintiff. But my
Again,
lord,
prove madidira. And the first appellate court says that except western boundary, all other boundaries do not tally. Then
because changes 1962 in between 1967
they are who has to say
lot of
that?
changes. That is my lord, because of
Who has to say that? You have to say that.
provided to
Please call for records.
the plaintiff was availed a benefit of the statement. Tendency of things.
Please call for records. Party shall maintain status with respect to the property in to the next set of hearing. Section DS. Passport. Sir, 9/11/2011 ನಲ್ಲಿ ನೀವು ಅಪೀಲ್ ಹೆಂಗ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ? ಅಪೀಲ್ ಇಸ್ ಫೈಲ್ಡ್
And the other suits are also pending. He has filed a suit against me, and the sale is challenged by the client in Haryana.
I think what is the effect of this person dying?
The interference occurs. He still not will have those.
This injunction, please listen to me. Injunction is applicable only against Sanna Beatappa. Sanna Beatappa ತೀರೋದ್ರು. So how is this appeal maintenance purpose? It is stated by the learned counsel for the appellant that the appellant read on 9/11/2021. Full stop. The suit from which the present appeal arises was for the relief of perpetual injunction, and the appellant herein was the plaintiff before the trial court. Full stop. Since the plaintiff has expired, the suit abates. The suit as well as this appeal abates. Full stop. In that way of the matter, the appeal is disposed of as having abated.
I am for the appellant, my lord. I am for the appellant.
Yes.
Suit for declaration and in possession filed against KEB was dismissed by both the courts. Concurrent findings are there. My case is that I am the owner of the property. 20 guntas in the said property is not acquired on behalf of KEB at any point of time, and they have illegally encroached upon the same, and they have constructed a lineman quarters. And as such, I filed suit for declaration and possession. Whereas the DW1, an official of the KEB, appeared before the court, he has not produced any document to show that it was acquired by the government or it was acquired by the KEB. He has produced certain documents to show that lineman is residing in the said premises, and they are deducting HRA and other things from him, except that they have not produced anything.
So what have you produced to show that part of the land was acquired?
My case is that it is not at all acquired. They have illegally encroached and they have constructed lineman quarters.
Why is the suit dismissed?
Suit dismissed on the ground because the plaintiff, in his evidence, he says that he is in possession of the entire settled property as owner. Only based on that, it was dismissed.
Please read that court.
It is extracted in the trial judgment of the trial court only.
And how does the first appellate court deal with this?
First appellate court also says that I have not produced any document to show that my title, because I have produced a one release deed executed. In that, this property is not mentioned. In respect of all the properties, 2 shares were made. In respect of 1 share, she releases rights.
The issue notice call for records.
Appearing for respondent.
Yes, please. You don't have a case. You don't have a case. Why are you arguing so meekly? I can't even hear you. I can't hear you.
That the suit of the appellants as plaintiff before the trial court for declaration and perpetual injunction, and the trial court answered issues 1 to 4 affirmative and decreed the suit of the plaintiff's. So the defendant challenged the judgment and decree of the trial court before the first appellate court. The learned first appellate judge that has reversed the judgment and decree with the first appellate court on the ground that the plaintiffs had not filed counter rejoinder to the written statement and the defense set up by the defendant. Only on that point, the learned appellate court has come to the conclusion that the plaintiffs are not proved. And on behalf of the defendant, my lord, except he himself giving his evidence, and no witness has been examined to prove the documents tried by them, and all the documents produced by the defendants have been seriously disputed. And admittedly, those documents exhibits D1 to D2 to D5 are certified copies, and no witness has been examined to prove those documents. Exhibit D2 to D5 have been seriously disputed by the plaintiffs, stating that they are the sale deeds, and no witness has been examined on behalf of the defendant.
Sale deed witness examined.
With regard to proving of the disputed document,
who has to dispute that? The person. So the person who has executed the document, if he disputes,
that the person who has executed the document
Is not allowed. They say Bombay had executed the document.
ಬೊಮ್ಮಾಯಿ ಯಾರು ನಿಮ್ ತಂದೆ ತಾನೆ?
But even Kenchaya is also not alive, my lord. Both of them are dead. And sale deeds, at least they have been executed by Bombay and Kenchaya, have been disputed by the plaintiffs. And to prove those disputed documents, and the originals have not been admittedly produced. And no reason is forthcoming why original sale deeds are not forthcoming. Even the defendant has not produced even any extract of the encumbrance certificate to demonstrate that such a sale transaction had taken place. And exhibit P20 and 21, the exhibits are the encumbrance certificates obtained by the plaintiffs and produced. And those encumbrance certificates are from the year 1967 to 2013. In those encumbrance certificates also, the alleged sales transaction claimed by the defendant, he has no reference in the encumbrance certificates. And the defendant has not chosen to examine any witness to prove these documents. And under these circumstances, my lord, I humbly pray that the findings of the first appellate court is not based on the facts and evidence on record. The first appellate, the trial court has given cogent and concrete reasoning to answer issues 1 to 4 in the affirmative. And that reasoning has not been.
Appearing for respondent, my lord.
Yes, please.
My lord, so far as my lord, the execution of the sale deed has been denied by the plaintiff, sir.
Yes.
My specific plea before the trial court is that, my lord, to the extent of 1 acre of land is concerned, my lord, the plaintiff along with his father has executed the sale deed. With respect to 12 guntas is concerned, my lord, the husband of the second plaintiff.
Who executed the sale deed? Bommaya and?
The first plaintiff and his father Bommaya executed the sale deed to the extent of 1 acre is concerned under registered sale deed 21/5/1973 in favor of one Motaya. 21/5/1973.
Yes, in favor of Motaya.
In favor of Motaya, and the Motaya, my lord, who in turn executed the sale deed on 16/6/1975 in favor of my father Muni Maigaya.
Yes. What about the other
And so far as, my lord, the husband of the second plaintiff, my lord, and LRs of Kenchaya executed the sale deed to the extent of 1 acre in favor of Chikkanna under registered sale deed 21/5/1973.
21/5/73.
Howdo. Out of 1 acre, my lord, 12 guntas Chikkanna, my lord, who in turn executed the sale deed in favor of my father Muni Maigaya under registered sale deed, my lord, in the year 1973 itself. And so far as, my lord, the execution, my lord, the pursuant to the sale deed, my lord, mutation has not been effected in favor of my father. Hence, the trial court come to the conclusion, my lord, the defendant, my lord, they failed to prove the sale deed. And so far as, my lord, the first appellate court,
was any issue framed to that effect? Where are the issues? What are the issues framed?
In page number 37, do the plaintiff prove that they are the absolute owners and in possession of the suit scheduled property? Do the plaintiff prove that defendants are trying to interfere with plaintiff's peaceful possession? Whether the plaintiffs are entitled for declaration, whether plaintiffs are entitled for the relief of injunction, whether plaintiffs are entitled for the relief claim. My lord, the alter at the first instance, my lord, the suit has been filed for the relief of declaration and injunction. Later, my lord, they have sought for the consequential relief of possession to the extent of 1 acre 12 guntas is concerned. Decree ಹೇಳ್ತಾರೆ. Alternative consequential relief. In the event of the defendant, decree in the event of the defendant proves that he is the possession of 1 acre 12 guntas of land,
that possession has not been proved. Title of the defendant has not been proved kind of the pleadings. And there is also issue framed in the suit or also no issue has been framed even by the first appellate court?
Like the plaintiff, my lord, has not filed any rejoinder to my written statement. More than, my lord, exhibit D2, D3, D5 that my sale deeds, though have produced the certified copy, my lord, but plaintiff has not raised any objection while marking. And during the cross-examination also, my lord, he has not put any suggestion regarding the falsity of the sale deed. My lord, he has not put any questions on that regarding genuineness of the exhibit D2, D3 and D5 is concerned. Hence, the first appellate court come to the conclusion, my lord, the findings recorded by the first appellate court, internal page 36 of the judgment.
How have you denied the sale deeds? How have you denied it?
Well, they have been denied.
And the defendant cross-examination here the Kedira.
Well, those documents have been disputed, seriously disputed.
Why did you allow it to be marked?
Then those documents have been marked. Only the certified copies, they are not the originals.
So you allowed it to be marked. What is the cross-examination on those documents?
Even those documents are marked, my lord, they have been disputed, and those documents have not been proved by examining any
What
of
is
the
the
witnesses.
cross-examination? What is the cross-examination of the defendants on those documents?
Well, here production of the document cannot be.
Sir, what is the cross-examination of the defendants on those documents?
Well, we have stated that those documents are concocted. And
Did
those
you ask the
documents are
witness?
never in existence. Then no sale transaction has taken place. And admittedly, they have not produced any of the original sale deeds with that. And there is no explanation to that effect. When a document is disputed, again to the Supreme Court judgments of Imajama's case, that at least
Imajama's case was in respect of a will, Mr.
The Honorable Supreme Court has given the guidelines with regard to disputed document.
Imajama case course Gandhidira. Imajama case was regarding the valid execution of a will.
Not general guidance with regard to the genuineness, proving of a disputed document in a court of law.
Sir, you have an opportunity to dispute it before the trial court. What did you do is what I am asking you. Did you ask the defendant witness about this document? Did you ask him?
Except those two certified copies they have produced, the defendants have not chosen to produce any other additional documents in support of their contention. Yes.
So far as, my lord, the genuineness of the document, he has not cross-examined. The findings recorded by the first appellate court.
There is an issue regarding the execution of these documents by the plaintiff's predecessors in favor of the defendant. Where is the issue?
There is no such issues has been framed by the trial court. But so far as, my lord, the cross-examination, neither he has denied nor filed any rejoinder, nor cross-examined. Adr ಬಗ್ಗೆ issues ಯಾವುದು frame ಆಗಿಲ್ಲ. But the findings recorded by the first appellate court, he has not chosen to cross-examine regarding the genuineness of the exhibit D2, D3 and D5 is concerned.
Yes.
He has not at all denied the genuineness of the same also.
Yes.
There is no issue on that with regard to the.
What else?
There is no issue with regard to the title of the defendant.
What else?
Either before the trial court or before the first appellate.
ಅದು concocted documents ಅನ್ನೋದು ಆ ಒಂದು ಇದು ಇಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. So far as exhibit D2, D3 and D5 is concerned.
Please come to the first appellate court judgment, page 25.
Yes, my lord. From para 30 onwards, there is a findings recorded in that.
Wait, let him read. Internal page 25.
Page 22. Internal page 22. Reading of exhibit D2 show that plaintiff his father Bomaya have jointly sold 1 acre of land to one Challaya son of Kotaya on 21/5/1970. It is relevant to note that here itself that at the time of marking exhibit the certificate copy is sale date 21/5/2020. Plaintiffs have not at all objected. Though the defendants have pleaded with regard to the sale date 21/5/2011 is affidavit in way of terms of chief have not at all denied the genuineness of the same. Therefore, the pleading of the defendant, the plaintiff brother and his father Bomaya have sold 1 acre land and 21,573 remained undisputed. Added to the above, the evidence of BW and examination substantially contents of exhibit B2 dated 21/5/7. Though BW1 has subjected to the test of cross-examination, single session is also not directed to him to the effect that exhibit D2 is a contempt of SLD. The absence of any cross-examination should be recognized as exhibit D2. Based on the sole interested in testimony of BW1, the two in the absence of pleading cannot be said that exhibit D2 sale deed is obtained by Chalaya son of Motaya on 21/5/1973 in a fraudulent manner. Thus, the defendant has proved that the plaintiff number 1 and his father Bomaya have jointly sold 1 acre of land in Chalaya under the sale deed 21/5/1973. Is the contention of the defendant that Motaya sold 1 acre of land to Munima, father of the defendant, and the sale deed 16/6/1975. The substantive aspect of the matter given as reiterated the same and produced exhibit. The reading of exhibit would show that Motaya has sold 1 acre of land. Survey number 266 to Munimayega, father defendant, 166/73.
Contains is in the written statement also.
There is no issue to that effect.
This contention is raised in the written statement. You knew what the case of the defendant is.
There is no issue framed by the trial court or the first appellate court to that effect.
This appeal is filed by the plaintiffs, voice number 84 of 2012. On the file of the additional senior civil judge Ramnagara, challenging the divergent finding of the first appellate court in RA 47 of 2015, by which it reversed the judgment and decree passed voice number 84 of 2012. Next para. The partition henceforth we refer to as the arraigned with the child. Next para. The suit in OS number 84 of 2012 was filed for declaration and for future injunction with respect of the land bearing survey number 266 of Uragahalli, Ramnagara Taluk, measuring 4 acres 24 guntas. The plaintiffs claim that Bommaya, their predecessor, had purchased 6 acres of land in the aforesaid survey number from Narasimha Iyengar on 12/7/1967. He thereafter sold 20 guntas to Dundamma and retained 4 acres 24 guntas. Full stop. The plaintiffs allege that neither Bommaya nor they had alienated the suit property in favor of the defendant. However, the defendant was disputing the right and title of the plaintiffs to an extent of 1 acre 12 guntas, contending that he had acquired title over the same. Hence, the plaintiffs sought for declaration of their title to the suit property and for future injunction, and also sought the alternate relief of possession, recovery of possession of the suit property. The defendant contested the suit and claimed that Bommaya had 4 sons, namely plaintiff number 1, plaintiff number 7, and plaintiff number 7, plaintiff number 8, and Kenchaya, and 4 daughters. Full stop. The plaintiff number 1 and his father Bommaya executed a deed of absolute sale on 21/5/1973 to Motaya and conveyed 1 acre of land in survey number 266. Full stop. The said Motaya thereafter sold the said 1 acre to the father of the defendant on 16/6/1975, and the possession of the said land was delivered. Stop. The husband of the plaintiff number 2 and the legal heirs of Kenchaya sold 1 acre of land in survey number 266 to Chikkanna in terms of a sale deed dated 21/5/1973. To stop. Chikkanna thereafter sold 12 guntas to the father of the defendant. Full stop. The defendant therefore contended that he was in possession of 1 acre 12 guntas in survey number 266, and therefore the suit against the defendant was not maintainable. Full stop. He also contended that the plaintiff number 7 had executed an agreement in favor of the defendant on 13/11/2002, agreeing to convey 16 guntas of land in survey number 266. Full stop. He claimed that he had sunk a borewell in survey number 268/3 belonging to him and was drawing water from the borewell to the land in survey number 266, and that he was in possession of the 1 acre 12 guntas in survey number 266. Next, based on these rival contentions, the trial court framed the following issues. Stop. The plaintiff number 8 was examined as PW1, and a witness was examined as PW1, and exhibits P1 to P21 were marked. The plaintiffs examined PW2 as their witness. So on the other hand, the defendant was examined as DW1, and he marked documents at exhibit D1 to D6. Next para. Based on the oral and documentary evidence, the trial court held that the revenue records indicated that Bommaya, the predecessor of the plaintiffs, was the owner of the land bearing survey number 266, measuring to 4 acres 24 guntas. Full stop. The trial court held that the defendants had furnished certified copies of the sale deeds at exhibit D2 to D5, and the defendant had not furnished any revenue records to establish that he was that he was the owner of 1 acre 12 guntas of land in survey number 266. The trial court noticed that the plaintiff PW1 had admitted that 1 acre 12 guntas of land in survey number 266 was given to the defendant for cultivation. And it was not sold to the defendant or his father. Full stop. The trial court therefore held that the defendant had not established his title to the suit property based on exhibit D2 to D4, which were certified copies of the sale deeds alleged to have been executed by Bommaya and the plaintiff number 1, as well as the husband of plaintiff number 2 and LRs of Kenchaya, and thus decreed the suit for perpetual injunction, declaration of the title of the plaintiffs, and also granted injunction restraining the defendant from interfering with the possession of the plaintiffs. It also granted the alternate relief of recovery of possession of 1 acre 12 guntas from the defendant. So being agreed with the aforesaid judgment and decree, the defendant filed RA 47 of 2015. Next para. The first appellate court secured the records of the trial court, heard the counsel for the parties, and framed the following points for consideration. Stop. Document. The first appellate court held that the marking of exhibit D2 to D4 was not objected by the plaintiffs. Stop. It also held that the defendant, it also held that the plaintiffs did not suggest to the defendant, to DW1, that exhibit D2 to D4 were either fraudulent or concocted for the purpose of the suit. Full stop. It noticed the contention of PW1 that the defendant and his father were permitted to cultivate the land, and that the defendant was in possession of the said property. Full stop. If that be so, having regard to the first appellate court therefore took these key admissions and held that the defendant had proved the lawful execution of the sale deeds at exhibit D2 to D4, and thus allowed the appeal and dismissed the suit. So being agreed to the aforesaid judgment and decree, the plaintiffs are before this court in this regular second appeal. The learned counsel for the plaintiffs submitted that the trial court committed an error in not framing a relevant issue, namely the relevant issue regarding the alleged conveyance of 1 acre 12 guntas by the plaintiff number 1 and his father, as well as the husband of plaintiff number 2 and the LRs of Kenchaya. Stop. He submitted that the defendants also did not furnish the originals of exhibit D2 to D4, and therefore, the trial court and the first appellate court, which was bound to consider the relevance and admissibility of these two these documents, failed in its duty to consider the admissibility of these documents. Full stop. Next para. The learned counsel for the respondent / defendant, on the other hand, submitted that the case of the plaintiff was itself that the defendant was in possession of 1 acre 12 guntas of land on the assertion that the defendant's father had purchased it from the predecessor of the plaintiffs. Full stop. He therefore submitted that the plaintiff and the defendants were aware as to the case of each other's case, and therefore it was for the plaintiff to dispute or deny the execution of the sale deed in favor of the father of the plaintiff, defendant. Full stop. The learned counsel pointed out the finding of the first appellate court regarding the validity of exhibit D2 to D4, and contends that the first appellate court had considered the evidence in the right perspective and had held that the plaintiffs had failed to establish that they had not executed the sale deeds at exhibit D2 to D4. Next, I consider the submissions made by the learned counsel for the parties. Next para. It is evident from the judgment and decree of the trial court that the suit was filed on the assertion, based on the assertion that the plaintiffs had not alienated 1 acre 12 guntas of land in survey number 266 in favor of the defendant or his father. Full stop. The defendant had set out in his written statement the way in which this 1 acre 12 guntas of land was purchased by his father. Full stop. Therefore, it is clear that the plaintiff was aware about the case of the defendant. Also gave the of the sale. Stop. As rightly contended by the learned counsel for the plaintiff's the trial court must have framed an issue regarding the claim of the defendant. Be that as it may, since the plaintiff has proceeded with the case understanding the case of the defendant and has allowed exhibits D2 to D4 to be marked in evidence and not challenged the legality of the said document. The first appellate court was justified in refusing to grant the relief of declaration and perpetual injunction. Stop. In that view of the matter, no substantial question of law arises for consideration is appeal. Hence, it is dismissed.
Much obliged.
Plaintiff before the court. The appellant has filed suit for specific performance of the agreement of sale. Dated 23/4/2018. Terms of the agreement of sale. Sale consideration was rupees 4,95,000. 50,000 was paid as an advance. But subject matter of the property. Agreement of sale is a landed property. Wherein serial number 625 or year 35 in the situated at Kollega. But as it is 9 months time was fixed under the agreement of sale. Right? 9 months. For payment of balance consideration amount and also. But the revenue records were not transferred in the name of defendant. But legal notice was also issued on 10/12/2018 within the time, expressing the ready and willingness to pay the balance consideration amount and to pay the sale. But the defendant has sent reply notice. He has denied the execution of the agreement of sale and also his ownership over the property. But the suit is filed. Subsequently, the suit after full-fledged trial, Honorable Trial Court is pleased to decree the suit of plaintiff page number 50. The issues framed therein in all 7 are answered affirmatively in favor of plaintiff. But the defendant has preferred appeal for the Honorable First Appellate Court. Page number 14 minutes. Yes, but the Honorable First Appellate Court has taken a view that I have not proved the signature of defendant number 1 in the agreement of sale. But in fact, I have examined myself as a the attesting witness to the agreement of sale is examined as even the scribe of the agreement of sale is examined as and in my evidence, the signature of the defendant is also not marked as 5C. In the cross-examination of defendant number 2, my lords, please, he has admitted the signature, but the Honorable First Appellate Court has observed in there are 38. Confront ಮಾಡಿದರೆ ಅವರು ಡಿನೈ ಮಾಡಿದ್ದಾರೆ. Confront ಮಾಡಿಲ್ಲ. There are 38 page 20 each page 33. DW1 in his cross-examination denied that he has executed his P5 and received 50,000 as advance from the plaintiff. In cross-examination of DW1, the plaintiff has not confronted the signature of the defendant. Lords, please, I have certified copy of the cross-examination. If I am permitted, I will pass.
The DW2 Sudarshan has
he has also admitted. His signature, you are visible of page 16 affidavit submit. ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲೇ 5B confronted to him, he has admitted ನಂದೇ ಅಂದ್ರೆ ಸರಿ ಅಲ್ಲೇ
ಹೇಳಿದ್ದಾರೆ.
ನೆಕ್ಸ್ಟ್ 2 pages ಅದು ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ. ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 16 ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲೇ ತೋರಿಸಲಾಗಿ ನನ್ನದೇ ಅಂದ್ರೆ ಸರಿ. So this aspect and other aspect. Next is some categorically admitted ಹೌದು ದುಡ್ಡು ಎಷ್ಟು ಅಂತ ನಾನು ಇವತ್ತು ಹೇಳಿದರೆ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಂಡು ನಿಜ 9 ತಿಂಗಳಲ್ಲಿ ಅವರು ಬರ್ಸ್ಕೊಂಡು it is in page number 18 and so far as ownership also the DW1 has categorically admitted in his cross examination that these aspects the learned first appellate court has
Mr. R.S. Ravi.
R.S. Ravi.
Then for that 1998, there was partition among both of them. At that time, daughters were given some cash, jewels and other things. He did not want the.
How is that partition proved?
Then the exhibit T26 on two grounds, it has been not accepted. But what has happened is, now, except fifth response, Palacharappa's, Panchacharappa's daughter's son, one of the sons, all others have agreed and agreed to share some property either in cash or the fifth respondent son ಸ್ವಲ್ಪ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀವಿ. Fifth respondent, now Vishwanath appears for fifth respondent. If he is able to convince fifth respondent son, others have agreed. Sisters have also agreed.
A.K. Vishwanath.
One of the sons, who is not of course party, but his consent may be required.
Why is his consent required?
Father and son, ಅವರಲ್ಲೇ ಮತ್ತೆಲ್ಲರೂ ಹೋಗಿದ್ದಾರೆ.
Yes, Mr. A.K. Vishwanath.
Correspondent.
ಯಾವತ್ತು ಹೇಳ್ತೀರಿ?
2 ವಾರ ನಂತರ
2 ವಾರ ಇಲ್ಲ ಸರ್.
ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ಲೆಲ್ಲ ರಿಪೋರ್ಟ್ ಮಾಡಿ. This is all, I may not be able to successfully urge for allowing the appeal because it is
That is the case, then let to discuss this appeal. FD Pilbek settlement. Let them report a settlement.
It is also fine.
This appeal is filed by the
first defendant.
Defendant number 1. Invoice number 73 of 2007. Challenging the concurrent fine 73 of 2007 on the file of the senior civil judge and JMFC. Soraba. Challenging the concurrent finding of fact that the plaintiffs are entitled to 1/6.
Plaintiff is entitled to, but
plaintiffs are entitled to undivided share in the suit's real properties. Expert. But notional share ಕೊಟ್ಟಿದ್ದಾರೆ.
Notional ಕೊಟ್ಟಿದ್ದಾರೆ, appeal ನಲ್ಲಿ notional ಕೊಟ್ಟಿದ್ದಾರೆ. Trial court ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, modify ಮಾಡಿದ್ದಾರೆ appeal ನಲ್ಲಿ.
First appellate court ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
136 share to the daughters and appellants G45 and 836 share. Modify ಮಾಡಿದ್ದಾರೆ.
When did the father die?
Father died in 1994.
So because of that.
Yes, because of that.
Suit is filed in which? Suit is filed in 2007.
7 minutes. Suit is filed in 2007. Father died in 1994 minutes on 29/4/94. My contention is not that there was a partition under exhibit T26, which is a Palupatti Milord. It did not require registration.
But that is not.
ಅದು ಒಂದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ನಾನು ಹಾಕಿರೋದು. ಇನ್ನೊಂದು ಏನು ಅಂತಂದ್ರೆ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಹೆಸರಾಗಿತ್ತು ಶಿವಮೊಗ್ಗದಲ್ಲಿ, ಅದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಅದು ನೆಗೆಟಿವ್ ಮಾಡಿದ್ರು. ನಂತರ ಅಪೀಲ್ ನಲ್ಲಿ ಅದನ್ನು ತಗೊಂಡೆ, ಅದು ನೆಗೆಟಿವ್ ಆಯ್ತು. ಓನ್ಲಿ ಕ್ವಶನ್ ದಟ್ ರಿಮೈನ್ಸ್ ಇಸ್ ದಟ್ ಎಕ್ಸಿಬಿಟ್ G26 is a partition which is not registered. Of course, my contention is it does not require for registration.
No, otherwise, notional share control. Notional shares are entitled. Father died.
But ಅದಕ್ಕೋಸ್ಕರ ಕಾಂಪ್ರಮೈಸ್ ಏನೋ ಆಗ್ತಾ ಇದೆ. ಅಲ್ಲೇ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಬಹುದು, ಅವರು FTP ನಲ್ಲಿ ಮಾಡ್ಕೊಬಹುದು. Because they have not filed any appeal.
The plaintiffs, the suit in OS number 73 of 2007 was filed for partition and separate possession, contending the plaintiffs were the daughters, while the defendants 1 to 4 were the brothers, were the sons of late Patel Basavanyappa Gowda. So the plaintiffs contended that they were intent that they were in joint possession, enjoyment of the scriptural properties, and that they were not partitioned. Full stop. They claim that after the death of their father, the defendants 1 to 4 were not accounting for the proceeds from the joint family estate, and that they had cut and removed teak trees valued at rupees 20 lakhs situated in the suit property, and had distributed the proceeds amongst themselves. Full stop. Therefore, the plaintiffs were constrained to demand their share, which was refused by the defendants, and this prompted the plaintiffs to seek further share. Stop. The defendant number 1 contested the suit and claimed that their father died on 29/4/1994, and that but partition ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಈಗಲೂ ವಿಭಾಗ ಆಗಿಲ್ಲ.
ನಾವು ಸೆಟಪ್ ಮಾಡಿ 98 ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ಎಕ್ಸಿಬಿಟ್ T26. Very similar the issues there. Whether the defendants want to vote no.
Stop. He claimed that there was a partition of the suit properties on 1/5/2001.
On 30/5/1998.
ಹೇಳಿದಿರಿ.
ಇಲ್ಲಿ issue ನಾನೇ ಇದೆ 35/98 ಇದೆ exhibit T26 pelot.
35/1998.
All partition that took place evidence by Melod exhibit T26 ಇದೆ 35/98. Issue number Melod 3. Whether defendants want to
whether this trial court has recorded the rejoinder to this written statement or what? Paragraph number 3 nalli of the trial court judgment, it looks like the trial court has extracted the rejoinder of the plaintiffs as the written statement of the defendant number 1. Noting. ವಾದಿಗಳು ಹೇಳುವ ಅಂಶಕ್ಕೆ ಸರಿ ಇರುತ್ತದೆ. ದಾವ ಎ ಬೀಸಲು ಅನುಸರಿಸುವ ಪ್ರತಿಯೊಬ್ಬ ಒಟ್ಟು ಎಂಬುದು ನಿಜ. ಒಟ್ಟು ಕುಟುಂಬಕ್ಕೆ ಸಾಕಷ್ಟು ಆದಾಯ ಇತ್ತು ಮತ್ತು ಅವರ ತಂದೆ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ ಎಂಬುದು ನಿಜ. ನಂತರ ಗೌರಮ್ಮ ಮೃತಪಟ್ಟಿದ್ದಾಳೆ ಎಂಬುದು ನಿಜ. ಅವರು ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಈಗಲೂ ವಿಭಾಗ ಆಗಿಲ್ಲ ಮತ್ತು ಜಂಟಿಯಾಗಿ ದಾವ ಆಸ್ತಿಗಳನ್ನು ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಾರೆ ಎಂಬುದು ನಿಜ. ಸದರಿ ಬಸವಣ್ಣಪ್ಪ ಗೌಡ ಮೃತಪಟ್ಟ ನಂತರ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಮುಂದುವರೆದುಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ ಎಂಬುದು ಸುಳ್ಳು. ವಾದಿ ಪ್ರತಿವಾದಿಗಳ ಮಧ್ಯೆ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಗಳಲ್ಲಿ ಹಿಸ್ಸೆ ಆಗಿರುವುದಿಲ್ಲ ಎಂಬುದು ಸರಿಯಲ್ಲ. ವಾದಿಯರು ಒಂದೇ ದಾವ ಸ್ವತ್ತುಗಳು ತಮಗೆ ಇದ್ದೇವರೆಗೂ ಸುಳ್ಳು. ಸಾಕಷ್ಟು ಯಾವುದೇ ಆದಾಯ ಇರುವುದಿಲ್ಲ ಎಂದು ಸಂಪಾದನೆ
ಪಾರ್ಟಿಷನ್ ಸೆಟಪ್ ಮಾಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ಆವಾಗ ದುಡ್ಡು ಕೊಟ್ವಿ ನಾವು ಅಂತ ಹೇಳ್ತಾರೆ.
You please come to page number 3 of the trial court judgment, internal page 3, last but 4 sentences ಓದಿ. ಒಟ್ಟು ಕುಟುಂಬದಿಂದ ಬಂದ ಯಾವುದೇ ಹಣ
ಮತ್ತು ಮರಗಳನ್ನು ಮೂರನೇ ಪ್ರತಿವಾದಿ ಕಟ್ಟಿರುವ ಮನೆಗೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ ಮತ್ತು ಉಪಯೋಗಿಸಿರುವುದಿಲ್ಲ. 3598 ದಿವಾಳಿ ಇಚ್ಛೆ ಆಗಿದೆ ಎಂದು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಹೇಳುವುದು ಸರಿಯಲ್ಲ.
ಏನಂದ್ರೆ
ಈ ಮೂರನೇ ಪ್ರತಿವಾದಿ ಇರ್ಬೇಕು ಮಧ್ಯ, ಮೂರನೇ ಪ್ರತಿವಾದಿ ಇರ್ಬೇಕದು. ಅದು ಮೂರನೇ ಪ್ರತಿವಾದಿ ಆತರ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ.
Stop. We therefore contended that the plaintiffs are not entitled to a share in the suit properties. Stop. The defendants 2 and 5 did not contest the suit. The defendant number 3 contested the suit and claimed that he had purchased he had constructed a house out of his own savings. And that he had not utilized the funds of the joint family for that purpose. He also claimed that they said that the partition deed dated 30/5/1998 set up by the defendant number 1 was incorrect. He prayed that the suit be decreed and his share be demarcated. Full stop. The defendant number 4 contested the suit and claimed that the parties had partitioned the suit properties on 30th of May 1998 and that they were in possession of their respective shares. He alleged that the plaintiffs were paid substantial cash and substantial cash at the time of their marriage, and therefore they are not entitled for any share in the suit properties. So based on these rival contentions, the trial court set down the case for trial. The trial court framed issues and set down the case for trial. The trial court held that the plaintiffs had proved their relationship with the defendants and also that the suit properties were properties that belonged to the joint family and therefore were available for partition. It, however, negated the contention of the defendant number 1 and 4 that the suit properties were partitioned on 30/5/1998 as per Exhibit D26, as Exhibit D26 was not registered in accordance with law, and the plaintiff defendant number 1 and 4 were unable to prove the valid execution of the said power of attorney. Even otherwise, the trial court held that the plaintiffs were daughters and were entitled to a notional share in the suitable properties, and thus decreed the suit and declared that the plaintiffs are entitled to an undivided share in the A and B schedule properties. Being ignored the aforesaid judgment and decree, the defendant number 1 alone challenged the filed RA 240 of 2010. The first appellate court secured the records of the trial court, heard the counsel for the parties and framed the following points for consideration. The first appellate court held that
unregistered document.
First appellate court held that the plaintiffs are not entitled to an equal share of the suitable properties, but are entitled to only a notional share, since the father of the plaintiffs died on the date till 1994. Full stop. also held that the defendant number 1 and 4 had failed to prove the lawful execution of the partition, unregistered partition dated 30/5/1998, and hence modified the judgment and decree of the trial court and declared that the plaintiffs entitled to 1/35th share, while appellant, while
and sixth,
plaintiffs and R6 are
sixth of the daughter. Nannade R6
and defendant number 6, defendant number 5,
defendant number 6
Lalitamma,
6
5, defendant number 5, and defendant number
5 and 5.
defendant number 5 are entitled to 1/35th share, while the defendant number 1 to 4 were entitled to 8/35th share in the A and B shell properties. Stop being agreed with the aforesaid judgment and decree, the defendant number 1 has filed his regular second appeal. Next, the relevant counsel for the defendant number 1 submitted that the parties had entered into a partition 35/1998, and therefore the suit properties were not available for partition in view of the fact that they were subject, in view of the fact that the Hindu Succession Amendment Act 2005 did not invalidate the partitions entered into before 20th of December 2004. Full stop. Next para. The perusal of the impugn judgment and decree of the trial court and the first appellate court indicate that the father of the plaintiffs died on so and so, and therefore, the plaintiffs being the female heirs were entitled to a notional share in the share of their father upon his death. Stop. Therefore, even if a partition deed is entered into between the defendants 1 to 4 on 30th of May 1998, the defendants cannot claim that the plaintiffs do not have any title or interest in this property. In that view of the matter, the first appellate court has rightly considered the shares allotted to the considered and declared the shares to which the plaintiffs were entitled to. Stop. There is no error committed by the trial court and the first appellate court. Therefore, yes.
Yes, my lord. In this case, I appear for appellants, my lord.
Yes, madam.
Defendants appeal, my lord.
Yes.
There is a concurrent finding, my lord. The plaintiff, the G3 is, my lord, at page number 68, my lord.
Yes, madam.
Juan Mentaro and Serafin Mentaro had 2 children, my lord. Plaintiff is the first daughter, my lord, and Robert is the deceased son of Juan Mentaro, my lord. The different appellant number 1, different number 2 is the daughter-in-law of Juan Mentaro, my lord. His son is died, my lord. My lord, the properties, my lord, he filed, the Juan Mentaro has filed application under Section 48 of Karnataka Land Act and sought for a confirmation of occupancy right.
Yes. Yes, madam.
And thereafter, my lord, on the basis of grant, my lord, he had executed a will in favor of his wife. She has made a party before the trial court, my lord. Yes, defendant number 1. During the pendency of the suit, my lord, she died, my lord.
Yes.
Executed a will in favor of his wife, my lord, on 22/4/1982, my lord. Will has been proved, my lord. But the trial court has taken a wrong contention, my lord. Under suspicious circumstances, will has been not proved, my lord. Taking wrong. wrong date of death of Juven Montero, my lord. In the plaint itself is, my lord, they have mentioned the date of death, my lord, 17/5/1987, my lord. The court has taken a wrong date, my lord, 27/83, my lord. Therefore, there is a suspicious circumstances in regarding the execution of the will, my lord. On that ground, my lord, will has not been
According to
proved.
you, when did Giovanna Pinto Montero die? In the year 1982, according to you.
No, my lord. In the plaint itself, my lord, they were also mentioned under it in the
The
written
plaint,
statement.
madam. Forget the plaint. You say in your written statement that Giovanna Montero died in the year 1982.
That is wrong date, my lord. That is, they were mentioned, my lord. In the plaint itself, my lord, they have mentioned that 17/5/1987, my lord. After execution of will, my lord. On the basis of that will, my lord, the first defendant, she died during the pendency of the suit, my lord. She has executed a unregistered will in favor of her daughter-in-law, my lord.
Right, but what is the right of this lady to execute a will, madam? The property belongs to the family.
This is granted land in favor of his husband, my lord.
So?
Parties are Christians, my lord. Indian Succession Act is applicable, my lord.
What was the, as on the date when you filed an application before the land tribunal?
Please, my lord.
Yes, what did he say? Forum number 7 produce ಮಾಡಿದಿರಾ?
Forum number 7 produce ಮಾಡಿದ್ದೀವಿ.
ಏನಂತ ಹೇಳುತ್ತದ್ರಲ್ಲಿ?
Please, my lord. My lord, in the before the trial court, we have not produced, my lord. We have filed application in the appeal, my lord, along with will and and also the death certificate, my lord. That has not been considered by the appellate court, my lord. There is no finding given on the additional documents produced by the appellant's defendants, my lord. And moreover, my lord, Exhibit D3, D2 is the letter of District Court Dakshin Kannada, Mangalore, my lord. Form number 10, my lord, regarding, my lord.
Form number 7 ಎಲ್ಲಿದೆ?
ಇದೆ. My lord. Exhibit D3, my lord, that is the D2, my lord.
Form 7?
Please, my lord.
What does it say? ಏನು ಹೇಳುತ್ತೆ Form number 7?
On behalf of him, my lord, he has filed, on behalf of annuity to the benefits of family members, he has not filed, my lord. That application is here, my lord.
Where is the Form number 7? Where have you produced? How do you say that this property was granted to him exclusively? He has succeeded to inherit the tenancy.
My lord, moreover, my lord, in the will itself, my lord, she has admitted that, my lord, at the time of marriage, my lord, 6 pavan gold she has given, my lord, and also given 25,000 rupees to the plaintiff, my lord. But but in the young age of the second appellant, my lord, second defendant, my lord, her husband was died, my lord, leaving behind 6 children, my lord. Properties, my lord, 3 acres, 56 cents, my lord. If they are entitled half share, my lord, but my party will suffer, my lord. Only she will get 1 acre, my lord, 25.
No, your client has got how many children? 1, 2, 3,
6 children, my lord. 6 children. Please, my lord.
6 ಜನ ಮಕ್ಕಳು ಏನ್ ಮಾಡೋದು?
My lord, in the appellate court also suggested for settlement, my lord. In their, my lord, they have not agreed, my lord. If notice is gone, my lord.
Notice, madam.
Before this court, my lord, maybe there is a possibility of settlement, my lord.
Yes, madam.
Only
No,
notice.
we can't issue notice thinking that they'll settle, madam. Yeah, merits is real.
Merits, my lord, the appellate court has not considered my application filed under order 41 rule or 27, my lord.
No, but that you
My lord,
attempt to produce.
Will, my lord,
You
there is a
attempt to produce a will executed by the defendant number 1 and
Yes, ma'am.
her death certificate. Erade.
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಇನ್ ದಿ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್ ದಿ in the original suit my lord we have produced earlier will my lord executed by Juan Mentoro in favor of first defendant.
Yes.
First defendant has in turn she has executed a will in favor of second defendant.
What I am also saying, madam.
Please, ma'am.
You try to produce the will executed by the defendant number 1.
Please, ma'am.
And her death certificate. Correct?
Please, ma'am.
That is not considered by the first appellate court.
First appellate court, my lord.
Question is, if you are not proved the execution of the will in favor of the defendant number 1, how could she execute a will? That is a question.
My lord, in the trial court, my lord, we have examined one witness, my lord, regarding proving of will, my lord, that has been considered, but only taken a wrong contention, my lord. He died in the year, my lord, after the execution of will, my lord. That is not correct, my lord. In the plaintiff itself is the plaintiff has admitted that he died in the year 87, my lord. Only under the suspicious circumstances.
Adhe settlement marsi no.
FDP is pending, my lord. FDP is pending.
Madam, notice issue madidini.
Please, my lord. Please, ma'am.
If you want any further order, we'll decide the case now.
God bless.
Pardon? All the defendants related, plaintiff and defense related. Defendant died. Then how is the appeal maintained? Huh? Correct, you sathadna henge interfere ಮಾಡ್ತಾರೆ. How did you bring the LRs, Mr. This appeal is filed by the plaintiff. Invoice number 67 of 2010 on the file of the principal civil judge in Malavalli, challenging the divergent finding recorded by the first appellate court in RA 33 of 2015, by which it reversed the judgment and decree passed by the trial court and dismissed the suit. Next para. The learned counsel for the appellant/plaintiff submitted that the defendant died during the pendency of the appeal before the first appellate court. And therefore his LRs are brought on record. Next para. It is seen from the judgment and decree of the trial court that the suit filed in OS number 67 of 2010 was for future injunction. Stop. If that be so, the cause of action abated upon the death of the defendant. So therefore, this appeal does not survive for consideration as it is abated. Or makku mele hakoli yaru bidan. MJ Alva.
Insufficiently stamped and unregistered payment of sale containing the recital of delivery of possession was got marked subject to objections. The trial court says even though it is not registered, it doesn't require because it is not a title. That is a view taken by the trial court. The first appellate court takes the view that it has not been properly stamped. Therefore, the argument of the
appellant is valid, your lordship will find in para 15, page 26.
Para 15.
15, page 26 of the first appellate. May I read this now?
Yes, please.
In fact, exhibit P1 has been marked subject to objections. Therefore, the observation of the lower court that the defendants did not raise any objection for marking the document is to be held erroneous. Hence, the plaintiff should have paid deficit stamp duty and 10 times of the penalty on the said document as required by section 33 and 34 of the Karnataka Stamp Act. Even as regards exhibit P2, there is a recital that ಈ ಕರಾರಿನ ಆಧಾರದಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಮನೆಯಲ್ಲಿ ವಾಸ್ತವಿರಲು ಎರಡನೇ ಪಾರ್ಟಿಯವರು ಮೊದಲನೇ ಪಾರ್ಟಿಯವರು ಅವಕಾಶ ಒದಗಿಸುತ್ತಿರುತ್ತಾರೆ. In fact, even in exhibit P2, there is a recital that the possession of the house situated in the paid schedule property has been given to the plaintiff. Therefore,
agreement ಅಲ್ಲಿ ನೀವು ವಾಸ
agreement ಅಲ್ಲಿ ಇದೆ ಅಂತ ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ವಾಸ ಇದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡೆಲಿವರಿ ಪೊಸೆಷನ್
ಇಲ್ಲಿದೆ. They continue to be in possession ಅಷ್ಟೇ.
ಹೌದು, ಈಗ ಅದನ್ನ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ವಾಸ ಇರ್ಲಿಕ್ಕೆ ಅಂತ.
You permitted them to
continue. Then you will not will see further. In fact, even in exhibit P2, there is a recital that a person of the house paid schedule property has been given to the plaintiff. Therefore, both exhibit P1 and P2, as per the recital, should have been written on insufficient stamp paper on the basis of the market value of the property. To that extent, the objection of the counsel for the defendant appellant is to be held acceptable. Now, my lord, the trial court says it is, even though it is not registered, it doesn't require registration. Now, in this case, rely upon the judgment of our trial court.
Admit issue notice. Call for records. The substantial questions of law which arise for consideration is appeal is whether the first appellate, whether the trial court and the first appellate court committed in a error, whether the trial court committed an error in not framing an appropriate issue regarding the admissibility of the document at exhibit P1,
P1 and P2.
P1 and P2. Number 2, whether the first trial court and the first appellate court committed an error in considering that exhibit P1 and P2 did not require registration, since it was stated in the agreement that the possession of the property would continue to be with the plaintiff. Whether the exercise of discretion by the trial court and the first appellate court was arbitrary. The exercise of discretion under section 20 of the Respondent Relief Act by the trial court and first appellate court is arbitrary. This paper books to be filed within 8 weeks. The operation and execution of the judgment and decree invoice number 198 of 2010, which was confirmed in RA 19 of 2018 are state.
Readiness and willingness.
Discretion and it covers everything.
Here, the issue of notice does not amount to proof of readiness.
What was the amount paid?
It is 45,000.
What was the total consideration?
2,65,000.
Whether the trial court and the first appellate court consider the question of willingness on the part of the plaintiff to conclude the transaction, and whether mere issuance of notice calling upon the defendant to conclude the sale transaction amounted to his willingness to complete the transaction.
appeal. Filed for declaration, not that the plaintiff is the absolute owner of the property. And to delete the charge created in favor of cases. This was the ruling that we had fought for. But the trial court dismissed this issue. No appellate court has allowed the appeal filed by the plaintiff. But maintenance, what these two decisions was not maintained in view of the fact that the property was already sold in auction in 2010 on 24/6/2010. 2010. And the suit was filed on 4/8/2011. To delete the charge created in favor of cases. But in fact, where it is not happened.
What does the first appellate court say?
The first appellate court says that the plaintiff has not obtained any loan. Therefore, he is not bound by it. When we turn to page 33, to page 33. In fact, the judgment about 32 on 33 page.
So, but was there a partition between the plaintiff and his brother?
Partition deed that came into existence on 22/7/2008.
22/7/2008.
Exhibit P40.
When was the loan? When was the charge created?
But that was loan was obtained by one Joseph Roach, the brother of the plaintiff, in the year 1995.
Yes. So how is this plaintiff liable for that loan?
Yes, but my submission would be that the property, actually P13 is the bill that has been produced by the plaintiff. In that, he says that his mother, Benedicta, she was the owner of the property of 22 cents. Otherwise, 11 cents was given to the plaintiff, Canadian, and the remaining 11 cents was given to Joseph Roach. And thereafter, they say on 22/7/2008, there was a partition. And
what is the date of the will?
Date of the will 30th August 1997.
Yes. And this property was belonging to the mother. Now, how is the mother liable for the loan raised by the son?
No, you are not speaking. This property was given as security. And on 11th century, in 22/7/2008 partition case, he says that schedule A property under that partition deed came to the share of Valerian. And schedule B in that partition deed came to the share of Joseph Roach.
Yes.
So when this property was given in mortgage to A6, the entire brother had given 22 cents entirely to account. And my brother did not have title over the property. Question would be, which part of the property has been sold in auction that has been decided?
That is right. The auction purchaser will only get what?
The auction purchaser is not made a part. In fact, that's why I said, as far as the declaration relief is concerned, that may survive. But as far as the relief of seeking deletion of charge in favor of cases, that will not survive in view of the fact.
To the extent of the plaintiff share, it will not survive.
To that extent, my submission would be that ಯಾವ 11 cent sell ಮಾಡಿದಾರ
ಯಾವ ಮಾಡ್ತೀರಾ verify? When will you verify? For 2 weeks. Next month. Next Monday. Next Monday.
In fact, the entire loan amount of the fees are still
Next Monday. 8 or 18. Find out. Next Monday. Yes. Serial number 50. Password.
51.
Yes.
Divergent declaration. Title and decision of amount of in the first instance, the trial court decreed this. the first appellate court was reversed to findings.
Yes.
Answer is for the plaintiff claims the crime with respect to exclusion property to be steadily in 5/1/2008 executed by his father and maternal aunt. Both of them were had equal rights, and Tata was there with their name. She appears to have expressed her desire to sell the property. So both brother and sister have executed So
Please come to para 21 of the first appellate court judgment.
Para 21 of
First appellate court judgment.
From the above discussion, from the above discussed reasons, it is evident that the plaintiff suppressed the faction of elimination of 5.5 quintas in favor of the mother of Gulappa and Villappa, person to land in favor of Pramukha and Plain. The suppression of fact is blamed by the plaintiff for the or random of being and the court as per the victim of Honorable Appellate Court in AR 1984 wherein they are not held non-production and even non-mention of the release value tantamount to paying product. The major portion of land out of the quintas and the it cannot be held. But the plaintiff's father is more than possesses both extent of the quintas of land. Such property to school but total extent of
So, what is there to show that?
The fact is, so in terms of feet or so, a division is made from the family of the plaintiff's family and their cousins. So in the RDC, probably it is showing 10 quintas of land in the RDC in the name of both the plaintiff's father. So based on that, probably this is ignorant of that. But the defendant is not claiming title from that Munappa.
But Munyappa did not have title to sell 10 gundas is the finding. Attugunte ನೀವು ಹೆಂಗ್ ಮಾರಾಟ ಮಾಡಕ್ಕೆ ಅವನು ಇರ್ಲಿಲ್ವಲ್ಲ. How did he sell what he did not possess?
According to my instructions, by way of a division, a deed of transfer has been effected, not in terms of agriculture land, in terms of field. So agriculture land ಹಾಗೆ ಅದು ಕಾಡಿನಲ್ಲಿ ಬರ್ತಾ ಇದೆ, ಅದು ನೋಡ್ಬಿಟ್ಟು ಸೇರಿ ಬರುತ್ತೆ.
Sir, 10 guntas illiದೆ. 10 guntas you are talking of 10,000 square feet.
Dispute is only with respect to 1.5 quinta.
1.5 quinta ಸರಿ, ಈಗ 10 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಕ್ಕೆ ನಿಮ್ ವೆಂಡರ್ಗೆ ಟೈಟ್ಲ್ ಇಲ್ವಲ್ಲ.
Only to the extent of the 50% of what 10 quintas, the claim of
you are not getting it right.
What the 50% has got to other branch. So the total 10 quintas belong to the family of the plaintiffs only. So their uncles have in a partition or some other given to them. So the defendant is not claiming title to them. If they are claiming title to them, then the fact of suppression comes.
Yes.
Not the only dispute is to be the haggle. In a suit in OS 5.1, which is called against
Allappa and Gullappa.
In that suit, there was a dispute with respect to the property. A suit for injunction was filed. In That's the commissioner, court commissioner was appointed, the taluk surveyor was appointed. So he has demarcated the entire property, shown that 1.5 foot is enclosed by. So thereafter they have filed this for recovery. So the trial.
But this defendant was not a party in OS 541.
How do? It was not a party. That's why they filed a separate suit. This suit against the defendant, and the commissioner who had given the report in that case, he has been examined. That report is placed on record. He has been cross-examined. So based on that, the suit is filed. So these defendants do not have any title to how they got the property. They have not placed any material. The claim made by the defendant is in pursuance of a house list extract issued by the concern. So they don't have any title. The plaintiffs have a title, at least. But they just there are 23 of the judgment. So far as commissioner's report,
There are 23 the first appellate court.
House first of all, board number. As I have already discussed, point number 1 and 3, the trial court must read on the judgment of as on exhibits given as doing in person of 10 voters of finance number 2 and 4. And also reported they have shown one of the land. The trial court comes to conclusion different appellate has exposed to the land. So this is property, the reason that extra property which is detailed the exactly to that value whether these findings of the trial court is important as are carefully gone through the exhibition stage prepared with the exhibition stage only during class examination given before that he has so another puntas of the land and take the same pink color. Estimate of suitable was not consistent and corroborated to exhibit. During his class examination made the grand concept of the defendant, checked to report that his ignorance for submission that he was taken for showing pink color is in existence since 40 years. CW1 has also deposed in ignorance that defendant has erected small tab 60 to 70 years back itself. Even as per exhibit C1, defendant has produced documents with respect to his house, which number 35 measuring in 50 feet tile roof now, 15 to 50 backyard, and 25 off into 46 feet angala. During course of cross examination, made by the ground counsel for the defendant, safety group has categorically admitted that he has not shown in the C1 that 1.5 foot of the land has been closed. He admits that once he goes to the residence, how now it was not even even during the course of process.
The records known. All for records.
Even in the course of cross examination, he says that defendant has never
This Mr. Mahesh. Mr. Mahesh. ಎಲ್ಲ ನೀವೇ ಡೆವಲಪ್ ಆಗಿದೆ ಅಂತೀರಾ ಅದೆಲ್ಲ ಇಂಪ್ರೂವ್ ಮಾಡೋ ಕೊಟ್ಟು ಏನೇನಾಗುತ್ತೆ
grandfather has sold the property. He has taken the advantage of the revenue and is starting the name and buy this.
ಬರ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡ್ ಕಮಿಷನರ್ ಹೇಳ್ತಾರೆ ನನಗೆ 1.5 ಗುಂಟೆ ಅಕ್ವೈರ್ ಆಗಿದ್ದು ಎನ್ಕ್ರೋಚ್ ಆಗಿದ್ದಿಲ್ಲ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿ might show but in the cross examination ಹೇಳ್ತಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ 1.5 ಗುಂಟೆ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ರು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅವ್ನು ಹೇಳ್ತಾರೆ
Cross examination
please read ನೋಡಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ CW1 has categorically admitted that he has not shown in exhibit C1 that 1.5 guntas of land has been encroached. Page number 30. So, call for record. Page number 53.
53 I appear for the appellant.
Please come at 2:30.
Yeah. Number 78 ಇತ್ತು 80-year-old man. ನನ್ನ ceremony ಇತ್ತು ಬಂದಲ್ಲಿ ಬೇಗ 3:30 ಹೋಗೋ ಪ್ರದೇಶ ಆಗಲ್ಲ ಸಿಂಪ್ಲಿ ಅರ್ಜೆಂಟ್. I request this court to That matter first.
ನಾನು ಅದೇನೋ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಡಿ.
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಕೇಳಿದೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ ಡೇಟ್ ಎಲ್ಲದಕ್ಕೂ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ there is no case which doesn't have a date.
ಅಲ್ಲ ಸರ್, otherwise I may publish.
So there is one appeal which we decided suit is of the year decrees of the year 1956. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ, ಹಳೆ ಕೇಸ್ಗಳಿದೆ, ಫಸ್ಟ್ ಕೇಸ್ಗಳು ಫಸ್ಟ್ ಮುಗಿಬೇಕು, ಫಸ್ಟ್ ಬಂದಿದ್ದು.
Yeah.
ಆಯ್ತು ಬಿಡಿ ಮೇಡಮ್ ಇದು ಇದೆ ಆಯ್ತು ಯಾವ್ದು ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಇವತ್ತು ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದು ಅಷ್ಟೇ ತಾನು ನೀವ್ ಯಾಕೆ ಬರಕ್ ಹೋದ್ರಿ ಆಯ್ತು ಮಾಡಾದ್ಮೇಲೆ ಹಂಗೆ ಹೋಗ್ಬೇಕು ಇದು ಯಾಕೆ ಬರಸ್ಬೇಕು ಆಯ್ತು This revision petition lacks merit and the same is dismissed. Any observations contained herein shall not affect the rights of any other descendants of Aga Ali Askar Shirazi, established that the Bakarabad property was not dedicated to any religious or charitable purposes, and that the notification dated 7/6/1965 does not affect his or her right in respect of the Bakarabad property. This is, however, subject to all limitations prescribed under the Act of 1954 and the Act of 1990.
I appear for the appellant in this matter. This is defendant's appeal, my lord, the suit for partition and separate possession. Totally, there are about 8 properties are included. The defense which was set up by the first defendant, my lord, is insofar as suit item number 7 and 8, they are the self-record properties. And the defense was also set up that, my lord, it was there was a partition in 2004 during the lifetime of the father, but the partition date was not produced before the trial court. That therefore I have filed an application under 41 Rule 27 in this appeal. And another aspect, my lord, is that in the partition, my lord, that there are 2 more properties, my lord, that the survey number 84 measuring 1 acre 36 guntas and survey number 75/2 measuring 2 acres were not been included in the suit. But they are also to be divided, because if it is because those properties
established in the final decree,
but in those properties are not included. That now in the appeal that I have taken up a contention in the trial court, my lord, that such a contention is not taken before the trial.
I thought final decree is only a continuation of the proceedings. You can urge.
Yes, that I can urge that particular aspect insofar as the non-inclusion of the properties also.
Yes. What about this 41 Rule 27? What is the first?
41 Rule 27, that is the Panchayat Palu Parikat which was taken place during the lifetime of my father.
Yes. What does the first appellate court say about it?
My lord, that I should pay, but because this particular Panchayat Parikat was not placed before the trial court or before the first appellate.
Or it was not produced itself.
It's not produced. That the other sale deeds which were the first defendant is asserting that plot after division, he has acquired the property at item number 7 and 8. But those properties are acquired in the year 2005. But the trial court and the first appellate court have come to the conclusion that they are also the joint family properties, because no other source of income has been established by the first defendant.
Yes. Astella.
So it is all only that if it is disposed of, that will also kindly make an observation with regard to other 2 properties which are not included.
Entitled to raise all those contentions in the final decree proceeding.
So if an observation is made, that I can urge, of course, that
this appeal is filed by the defendant number.
All the defendants.
This appeal is filed by the defendants in OS number 61 of 2010.
There is a delay, my lord.
Delay, yeah.
Delay. The notice has been ordered on delay.
IA1 of 21 is filed for continuation of delay of 997 days in filing the appeal. Though the notice of this application was served on the respondents, they are not opposed to the application. It is stated in the affidavit accompanying the application that
ಅದೆಲ್ಲ ನೆಗೋಷಿಯೇಷನ್ ಮಾಡೋಣ ಅನ್ಕೊಂಡೆ ಇವರೆಲ್ಲಾನು they are all brothers, only hair splitting ಇದು ಇತ್ತು ಅದಕ್ಕೆ.
That the judgment and decree of the first appellate court was not known to them, as they were involved in their business and harvesting, business and business, and while some of the others were involved in the harvesting stuff. It is also claimed that due to a function in the family, all the elders advised them to sit across the table and settle the issue rather than battling before the court. So therefore, the defendants expressed their willingness to settle the issue. However, the respondents kept on dodging the issue. And after almost 3 months, the first meeting was convened. Whereat they disclosed that they would consult their husband and children. However, in February 2020, when another meeting was convened, the respondents went back saying that they would return within a week and clear the issue. In the meanwhile, due to COVID-19, the appellants lost a few of their loved ones, which postponed the settlement of the dispute. So later, the respondents had initiated final decree proceedings, and the petitioners and the appellants therefore then realized that the respondents are not interested to settle the dispute. So next paragraph. Since these governments are not opposed by the letter, opposed by the respondents, this court considers the said explanation as plausible and therefore accepts the same. Hence, the delay of 997 days in filing the appeal is condoned. Next paragraph. An application IA-2 of 2021 is filed for production of additional documents. The appellant has attempted to place on record a copy of the Panchayat Palupatti dated 5/3/2004. Not in dispute that the appellants were aware of this Palupatti. However, they had not made any attempt to place the same before the trial court or the first appellate court. An attempt is now made after both the courts held against the appellants to produce the partition deed. There is no explanation offered as to why the said document was not produced before the trial court of the first appellate. That way of the matter, IA-2 of 2021 is rejected. Main menu. This appeal is filed by the defendants in voice number 61 of 2010, challenging the concurrent finding of fact recorded by both the courts, declaring that the plaintiffs are entitled to
1 night, yeah.
stand for dismissal properties. Next para. The plaintiffs and the defendants are sons and daughters of Amaya and Lakkamma. Full stop. It is claimed that the suit item number 1 was the joint family ancestral property, and out of the income from the said property, the propositors had purchased item numbers 2 to 6 on behalf of the joint family. Full stop. After his death, the plaintiffs and defendants became the co-owners of the sued properties and were in joint possession and enjoyment of the same. Stop. It is claimed that since Ramaya was not worldly wise, the sued properties were managed by the defendant number 1, and he purchased suit items 7 and 8 from out of the income of the joint family and started mismanaging their scheduled properties. Stop. Thus, a suit for partition was filed. Next, the suit was contested with the defendants who claimed that contested by the defendants who, though admitted the relationship, contended that suit items 1 to 6 were the joint family properties, but item number 7 and 8 were the absolute properties of the defendant number 1, as he had purchased them out of his own earnings. So, based on these rival contentions, the trial court framed the following issues. The plaintiff number 1 was examined as PW1, and he marked documents exhibit P1 to P8. The defendant number 1 was examined as PW1, and he marked documents as exhibit P1 to P3. It is a partition ಬಗ್ಗೆ ಹೇಳಿಲ್ವಾ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ?
ಇಲ್ಲ, ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ, ಬಟ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಸ್ಪೆಸಿಫಿಕ್ಲಿ ಸ್ಟೇಟೆಡ್ ದಿ ಡೇಟ್.
The trial court held that in view of the admitted position that suit items 1 to 6 were the joint family properties, the plaintiffs were entitled to an undivided share therein. Insofar as items 7 and 8 are concerned, the trial court held that the defendant number 1 did not produce any material evidence to establish that they were purchased out of his own earnings. Stop. The trial court also held that though the defendant number 1 claimed that the suit properties were earlier partitioned, yet, he did not produce any documents to establish the same, and hence decreed the suit and declared that the plaintiffs are entitled to 1/9 share in the suit properties, along with the defendants. 1/9 share of the suit properties. Being agreed by the aforesaid judgment and decree, the defendants filed RA 2014. The first appellate court secured the record to the trial court, produced the evidence on record, heard the learned counsel for the parties, and framed the following points for consideration. Copy. First appellate court held that there was no cogent evidence to establish that the defendant number 1 had any independent source of income to purchase suit items 7 and 8. It held that since the joint family possessed items 1 to 6 which were capable of generating income, it inferred that items 7 and 8 were purchased from said income in the name of the defendant number 1, as he was the eldest male member in the family. Full stop. It also noticed that there was no proof regarding partition of the suit properties, and therefore dismissed the appeal and confirmed the judgment and decree of the trial. Being agreed by the aforesaid, the present second appeal is filed. Next, by learned counsel for the appellant/defendant submitted that the defendant number 1 had specifically contended that the suit properties were partitioned but due to reasons beyond his control, he could not produce the partition before the trial court at the first appellate court. Stop. He submitted that the suit items 7 and 8 were purchased from out of the income, out of the income of the defendant number 1, and the income of the joint family was not utilized in purchasing the said properties. Stop. He also submitted that certain other properties bearing survey numbers
84 and survey number 75 bar 2.
84 and survey number 75 bar 2 of which village?
The very same village. That the
of Commonalli. Of Commonalli. ಎರಡು ವಿಲೇಜ್ ಇದೆ, ರಾಂಪುರ ಅಂತ ಬರಿದೆ.
ಒಂದು I have said
so village are not included in the
both are situated in my appeal memorandum. I have stated both are situated at Commonalli,
but not included in the suit for partition. Therefore, the suit for partial partition was not maintainable. Next para. It is not in dispute that the suit items 1 to 6 were the joint family properties where the plaintiffs had an undivided share in the suitable properties. Full stop. Since the family possessed of sufficient nucleus, it is inferred that the defendant number 1 was administering the family was in possession of the income of the joint family. Full stop. Unless there was enough evidence to establish that the defendant number 1 had any source of income which he did not mix it up with the funds of the joint family, the irresistible conclusion would be that the defendant number 1 had utilized the funds of the joint family in purchasing suit items 6 and 7 and 8. Stop. The first appellate court, the trial court and the first appellate court have considered the evidence on record and have held that the plaintiff, the defendant number 1 did not produce any oral or documentary evidence to establish that he had purchased item number 7 and 8 out of his own funds. Full stop. In that way of the matter, the finding of the trial court that suit items 7 and 8 were purchased by using the funds of the joint family is being a question of fact, being a finding of fact, cannot be interfered by this court in the second appeal. So even otherwise, notwithstanding this, the perusal of the judgment and decree of the trial court and the first appellate court would indicate that the defendant number 1 did not produce any material in that regard. Full stop. Insofar as the contention that the two properties were earlier partitioned, except stating so, the defendant number 1 did not make any attempt before the trial court and the first appellate court to establish the partition. Full stop. A vain attempt made before this court to produce these documents, produce a Panchayati Palupatti was turned down by this court, and therefore, as on date, there is no material evidence to establish the partition, and hence the trial court and the first appellate court were justified in decreeing the suit for partition. This court does not find any error in the appreciation of evidence or the application of law to the facts and circumstances of this case, and therefore this appeal lacks merit and is dismissed. However, it is open for the defendant number 1 to establish that the land bearing survey number 85, 84 and survey number 74 bar 2 of
75 bar 2
of so-and-so village is also available for partition in final degree proceedings. Stop. The final degree court shall consider the same in accordance with law and pass appropriate orders.
Oh, bless.
Cool. This appeal is filed by the defendant challenging the concurrent finding of fact recorded by both the courts, by which it was declared that the plaintiff is the owner of the suit property, that she is entitled for perpetual injunction against the defendant from interfering with her possession. Next para. This appeal was listed for admission. The parties have reported that they have settled the dispute amicably and have filed a compromise petition. They filed a compromise petition under Order 23, Rule 3, read with Section 151 CPC, the terms of which reads as follows. Para 3 in the note. In terms of the compromise, the respondent / plaintiff has paid a sum of ₹5 lakhs by cash to the appellant defendant, who acknowledges the receipt of the same. So we also admit, the parties admit the terms of compromise. Stop. Next para. By virtue of this compromise, the appellant defendant, by virtue of this compromise, the respondent plaintiff has agreed to pay a sum of ₹5 lakhs as an ex gratia payment to the appellant defendant. And the appellant defendant has admitted the ownership of the respondent plaintiff and undertakes not to interfere with the possession of the plaintiff in the suit properties. Since the compromise is just and fair, the same is accepted, and the impugned judgment and decree passed by the trial court and the first appellate court are confirmed. Office is directed to the first of the parties are present in person and are identified by the respective counsel. They have signed the mark sheet of this court in token of the acceptance of the terms of this compromise. Office is directed to draw a decree in terms of this compromise. And also, ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ, ಕನ್ಫರ್ಮ್ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿಲ್ಲ.
Prayer ಅಲ್ಲಿ last prayer ಅಲ್ಲಿ
terms of this compromise. Consequently, release a decree stating that the decree passed in OS number 514 of 2011 and RA 1 of 2014 are confirmed. Sign ಮಾಡಿ. ಏನು ಇಲ್ದಿರೋದಕ್ಕಿಂತ ಏನೋ ಸ್ವಲ್ಪ ತಗೊಂಡೋಗಿ, ಏನೋ ಇಲ್ದಿರೋದಕ್ಕಿಂತ ಸ್ವಲ್ಪ ಏನೋ ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳುದು. ನಿಮ್ದು ಹಂಗೆ ಬರೀ ಕೈಲಿ ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು.
Main ground is that Appellate Court has already put in the case that is Sharma versus Rakesh. There was a transfer of, there was a petition way back in 1991.
Partition.
The father and the son. And after the death of the father in 1896,
Adin prove madidra partition.
the plaintiff itself herself had marked the documents, but both the trial court and the other circuit court has failed to fix that document.
ಇಲ್ಲಿ document is ಯಾವುದು? Exhibit. Partition produce ಮಾಡಿದಾರ?
It is a mutation. The father and the son has applied for change of Khata.
Change of Khata does not amount to mutation. It is a partition, Mr.
Yes.
Change of Khata does not amount to partition unless there is a clear understanding between the parties. This
analysis of the year 91 and 92. Pongadi Gramada Vasi, Puttappa, Pinna Suppappa, ಇವರ ಹೆಸರಲ್ಲಿ ಇರುವ ಈ ಬಾಜು ಕಾಣಿಸುತ್ತಿರುವ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನನ್ನು ಇವರ ಮಗ ಎಚ್ ಪಿ ಗುರುಶಾಂತಕರ್ ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ ಕೋರಿ ಕೊಟ್ಟ ಅರ್ಜಿಯ ಮೇರೆಗೆ
settlement ಮಾಡ್ಕೊಳ್ಳಿ. See, you should not allow.
The parties give usually 1/6 of the share, but because of the judgment they are present, it is based on the
1/6 ಕೊಟ್ಟರೆ ತಪ್ಪು ಅಂತ ನಾನು ಹೇಳ್ತಿರೋದು.
Since way back in 1990, sorry, the father died in the year 1996, and thereafter also the son, that is the appellant, he was acting as the karta. And thereafter, my lord, in 2006, all the property was changed in the name of the appellant. And thereafter, in the year 2011, they are filed and partition. They mean that they are not getting a portion of the property. But the law which was prevailing before 2005, my lord, it was the law that the half of the share belong to the father. In that, the partition should be half the portion of the property should be given to the lord.
The suit is filed in 2011.
2011, my lord. But all the transfer was over in the year 2006.
Transfer, Khate transfer ಅದು ಏನಾಗಿ? Khate transfer in the Khate is only for the purpose of paying, identifying the person liable to pay the land revenue. ಕಂದಾಯ ಕಟ್ಟೋದು ಯಾರು ಅಂತ ತೀರ್ಮಾನ ಮಾಡೋದು ಖಾತೆ. How can Khata be termed to be ownership? Settlement ಮಾಡ್ಕೊಳ್ಳಿ. ಇದೆಲ್ಲ if you allow this to come to the court, this is what happens. ಕೋರ್ಟ್ ಬಂದ ತಕ್ಷಣ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಒಳ್ಳೇದು. ಅದು ಸಂಬಂಧನೂ ಹೋಯ್ತು, ಆಸ್ತಿನೂ ಹೋಯ್ತು, ಎರಡೂ ಹೋಯ್ತು. Yes, when do you want it? No. ಬೇಗ ಮಾಡ್ಕೊಂಡ್ರೆ ಟೈಮ್ ಕೊಡ್ತೀವಿ, ಇಲ್ಲಾಂದ್ರೆ ಟೈಮ್ ಇಲ್ಲ. ಶೂಟ್ ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕ್ರಿ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ. 3rd week of April ರಜಾ. No. 3rd week, yes. 1st week ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ಯಾವತ್ತು? Up to 4th you can pick any date. Up to 4th. 7th April, at the request of the Government Council for the appellant, in order to explore the possibility of settlement.
Respondent merely filed the suit for declaration of mandatory injunction on the basis of UP dated 1964.
Madam, ನೀವು ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ 10 ಸತಿ ಬರ್ತೀರಾ ದಿನಕ್ಕೆ. I keep telling trial court cost title ನ ರೆಫರ್ ಮಾಡಿ ಅಂತ.
The respondent hearing filed the suit.
Right. Yes.
Containing that the suit scheduled property is listed on 10/9/1962 to the respondent's father by one son
Sanna Nanjappa. He had 3 children, my lordship. One is Mallappa, Shivanna, and Gangamma. The defendant, the plaintiff in the suit is the son of one Jayama. The Jayama is died in 1960. Long back, my lordship. After that, the Sanna Nanjappa has taken the defendant to his home and taking care of him.
Who are the plaintiffs and defendants related?
He was the sister son of appellant's father.
Plaintiff defendant and appellant to respondent to ಎಲ್ಲೆಲ್ಲ ಹೋಗ್ತಾರೆ ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು. Trial court cost title, please stick to the trial court cost title.
Appellant plaintiff ಇಲ್ಲಿರೋ appellants ಅವರ ತಂದೆಯ ಅಕ್ಕನ ಮಗ.
Defendants ಹೇಳಿ. How are the plaintiffs and defendants related to each other?
Defendant is the son of one Allappa Maharaj. Plaintiff is the daughter's son. It means defendant here in Ilakantaya's father, sister, son. They are claiming the 1962 in 10/9/2062. The Sanna Nanjappa has made a gift with respect to defendant. They are not disclosed anywhere, my lordship, till 2012. And 2012 they are filed as for declaration. I am claiming that no partition has whatsoever happened. One of my brother has my father's brother has died. That's why I am in the possession of entire property what our grandfather is. 2006 I have gifted the property with respect to defendant.
Are you trying to confuse me or are you confused? You are confused ಆಗಿದ್ದೀರಿ.
ಇಲ್ಲಿ ಇವರು 1962 ಡಿಕ್ಲರೇಷನ್ ಅದು ಇಫ್ ಮೇಲೆ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಯಾರು?
ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್.
Plaintiff or defendant?
Plaintiff claiming ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆಗಿರೋರು.
ನೀವು ರೆಸ್ಪಾಂಡ್ ಹೋಗಲೇಬೇಡಿ.
Plaintiff claim ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
1962 ನಲ್ಲಿ.
Yes, my lord.
ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ದು?
Sanna Nanjappa, who is great grandfather of my defendant's one. Great grandfather.
Yes.
See today they have not produced the gift deed made in 10/9/1962, my lord. Only on the trial court said that they are only produced the certified copy of the gift deed, which is taken 15 days before to file the suit, my lord. On that ground,
over PW 2 and 3.
PW 2 and 3. Jayama is the wife.
Issue notice call for the yes.
Then, when release is was the proposal is he has a wife of Uttama mother. Out of the Islam mother, the participation of the case of the case is that while he was up to the teacher mother, that was the suit property. So the family have retained a partition of 1976 mother. It is Urvis Tappa and the children have
Urvis Tappa and the children.
Very peaceful property was allotted to Urvis Tappa. And according to them, after the death of Urvis Tappa, it was created as the wife Nanjamma mother. So both the died in the state. So the property is the joint property and it is the joint possession of the parties. So
So in the year 2007, she demanded for the partition, that is the father. Specific defense of the defendant is that when the father was made in the name of the Lanjama mother, Lanjama is executed a gift deed in care of the first defendant mother. Out of love and affection, for the reason that Lanjama was unmarried mother, she was looking after his father. But the trial court is the suit holding that when the property was allotted to Guru Siddhartha and he died intestate, it becomes the Jack family property. And the suit matter is taken as per additional issue matter. Trial court claims the additional issue matter. Whether the defendant proves that the suit is bad for partial partition. For this matter, it is observation is made by the trial court at running page 50, internal page 19, parallel. We consider the parallel of the trial court.
Yes.
Later on, subsequently, Guru Siddhartha and plaintiff and other defendants have entered into a partition date as per exhibit P1. So both the documents are that is the registered partition marked from both the sides. Wherein the suit property and one canal, that is Kaneshwar Mari number 47/1 has fallen to the share of Guru Siddhartha, which is admitted by PW. So PW1 has admitted that apart from the suit property, there is a canal property. May I pass the details of PW1 is admitted by the PW1.
But this property fell to the share of Guru Siddhartha. So therefore, section 8 will apply, Allah.
Apart from the suit property, it is survey number 76. Apart from that, in the 76 condition, this property was also allotted to Guru Siddhartha. But basic has not included the said property number.
I think we'll assume that that property is also included. Section 8 apply agbekalva. Section 8 apply adre ellargu 1/5 share hogodu.
That is made by the first appellate court. Trial court has awarded 250.
So first appellate court madre sari alva.
But our contention is that additional issue with regard to additional issue. Another property is there which is not included by the plaintiff in the suit matter.
ಅದನ್ನ ಫೈನಲ್ ಡಿಗ್ರಿ ಕೇಳ್ಕೊಳ್ಳಿ. ಫೈನಲ್ ಡಿಗ್ರಿನಲ್ಲಿ ಈ ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅದನ್ನ ಸೇರಿಸಿಲ್ಲ ಅಂತ ಫೈನಲ್ ಡಿಗ್ರಿ ಕೇಳಿ. ನೋ ರಿಮೈಂಡ್ ಮಿಸ್ಟರ್. ಫೈನಲ್ ಡಿಗ್ರಿ ಅಂತ ಒಂದು ಹಾಕ್ಬೇಕಲ್ವಾ? ಅದ್ರಲ್ಲಿ ಹೇಳಿ ಈಗ ಕಣದ ಪ್ರಾಪರ್ಟಿ ಸೇರಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Apart from that, even the PW1 is admitted that he is not in the possession of the suit property. His issue number 4 was held in the negative manner, but the trial court admitted that the PW1 admitted that he is excluded from the property. For a moment, page number running case 71, para 18. Plaintiff has also admitted in his cross-examination that he had been known out from the possession of the suit property in the year 2006, a definite number of his stories. So he is not in possession of the property.
All right, perfect. This appeal is filed by the defendant number 1. Defendant 1 and 2. OS number 4 of 2018, challenging the concurrent finding of fact that the plaintiff is entitled to an undivided share in the social profits. The plaintiff claimed that the social properties were allotted to the share of his father, Guru Siddhartha, at a partition which was evidenced by a deed dated 7/7/1976. Full stop. It is claimed that Guru Siddhartha died on 23/7/1993, leaving behind his wife, Srimati Nanjamma, and the plaintiff and defendants. Full stop. The Kata of the suit property was transferred to the name of Srimati Nanjamma as per IHC 161 of 93-94. And she died later in the year 2009. Full stop. The plaintiff claimed that he said Srimati Nanjamma had created a document purported to be a gift deed by which the suit property was transferred to the defendant number 1. Full stop. He claimed that Srimati Nanjamma had no independent right to dispose of the said property to the defendant number 1, and therefore sought for partition and separate possession of his share in the suit property. Etc. The defendants 1 to 4 contested the suit and claimed that Gurme Siddhappa was a school teacher, was a teacher at a government school, and that he had purchased the suit property out of his own income and was therefore his absolute property. They claim that after the death of Gurme Siddhappa, the suit property was transferred to the name of his wife, Srimati Nanjamma, and therefore, she had bequeathed the suit property to the defendant number 1, and hence the plaintiffs were not entitled to any. The trial court framed issues and set down the case for trial. Based on the oral and documentary evidence, the trial court held that in view of the admitted position that the suit property fell to the share of Gurme Siddhappa at a partition on so-and-so date, on 7/7/1976, the suit property was his absolute property, and since he died intestate, the same was liable to be partitioned amongst the plaintiff and the defendants, and hence they are granted 2/15th share to the plaintiff. Full stop. Being agreed by the aforesaid judgment and decree, the defendant number 1 and 2 number 1, 2, 3, 4 filed RA 39/2020. The first appellate court considered that the plaintiffs and the defendants were the only legal heirs of Gurme Siddhappa, and therefore, by applying Section 8 of the Hindu Succession Act, Hindu Succession Amendment Act 2005, granted equal share to the plaintiffs and defendants. So, being agreed by the aforesaid judgment and decree, the present appeal is filed. The learned counsel for the defendant submitted that apart from the suit property, another thrash yard was granted to the share of Gurme Siddhappa, which was not included in the suit schedule, and therefore the suit was not maintainable Stop. Next paragraph. It is seen from the judgment and decree of the trial court and the first appellate court that the parties were all agreed to the fact that the suit property fell to the share of Gurme Siddhappa at a partition dated 7/7/1976. It is nobody's case that Gurme Siddhappa had executed any document conveying the property to his wife Srimati Nanjamma. It may be that the revenue records were transferred to the name of Nanjamma, but that in itself would not mean that the property should transfer to the name of Srimati Nanjamma. Therefore, Nanjamma did not have any absolute right to convey this property to the defendant number 1. Full stop. The first appellate court has rightly applied Section 8 of the Act of 2005 and has declared that the plaintiffs and defendants are entitled to 1/5 share in the suit properties. Full stop. In that way of the matter, this court does not find any error in the appreciation of evidence and the application of law to the facts and circumstances of the case. Hence, his appeal is dismissed. However, if the defendants consider that any other property that was allotted to the share of Gudmi Siddhappa was not included in the suit for partition, then they may do so in the final degree proceedings. Stop. The final degree court shall consider the same and pass appropriate orders. Yes, madam.
Both the trial court and the appellate court, my lord, have dismissed the suit, my lord, on the basis of Section 92. Lord, the property, my lord, originally belonged to one Nayaka, son of Devegoda. Now he gifted the property to Ananta Krishnananda Mata. My lord, and my lord, later on 5/6/1950, a trust was made by the Mata. The trustee, my lord, is an exhibit 2, making 12 members as trustees. Later, the Swamiji, along with all the other 12 members, my lord, after they passed away, there was another trustee, my lord, made on 5/12/2009. Lord, the defendants hearing, my lord, admit that it is a trust property. Lord, the plaintiff's contention is that they've been in possession of the property since a very long time. The RTCs of the property stands their name. But it is not in dispute, my lord, that the property is a trust property. But the only question regarding is regarding the possession of the property. But since the defendants hearing are trying to interfere, my lord, they have made another trust deed dated 7/1/2010.
But the suit is filed only for injunction.
Yes, my lord.
Then
It's filed only for injunction, my lord. What the trial court has done is, my lord, it has considered only Section 92.
how is the suit maintainable?
Lord, we are only claiming possession of the property. Lord, Section 92 is not applicable in this suit because, my lord, Section 92 is applicable where the matter is regarding the administration of the trust property or it is including any trustee appointment. Lord, none of us are claiming that the property is not a trust property. Both the parties are admitting the same. My lord, the only question is regarding the possession of the property that the defendants are trying to interfere.
How are you in possession? Notwithstanding the gift deed.
My lord, in the trust deed, my lord, one Chikka
Samaya.
Tamaya, my lord, was given the possession of the property for cultivating it. My lord, we produce a genealogy also, my lord, in which the Chikka Tamaya's son is Ramegowda. My lord, that is at exhibit. Lord, Ramegowda's son-in-law is Nagegowda. Nagegowda's wife is the said the plaintiff, Maya.
So Nagegowda is the son-in-law of Nagegowda. Son-in-law.
Yes, my lord.
Of Nagegowda.
Aliya Nagegowda's wife is Mayama. So he has been doing all the puja work of the temple. That is how Chikkatimaya was given the possession of the property and he was given rights for cultivating the same. But they produced RTCs to show that Chikkatimaya Ramegowda, Aliya Nagegowda is only in possession of the property. The fact that the property is a trust property is also not in dispute by that. Section 92, my lord, will again not be applicable, my lord, because we are not questioning the administration of the trust property. We are not questioning about the appointment of the.
Who are the defendants?
My lord, the defendants' contention is that the first defendant's grandfather and the second defendant's father have put in some amount for procuring the sites. in which the temple in question is situated. Well, they were not original trustees in the first custody. They have themselves made another trustee on 7/1/2010. Allowed the trustee made by the plaintiffs after the first members in the first trustee died are the elders of the original trustees. We have made a trustee dated 2009. But after that,
what is your interest? What is your interest in the property?
but the interest is that we are the legal heirs of the original trustees. The original trustee has been given the possession of the property and it is being under our cultivation and under our possession method since a very long time. RTCs are there to support our convention. Not only on the basis of the other trustee that what they executed subsequently may not the defendants were not right.
Correct, madam. You please come to the suit schedule. ಒಂದು ಕೆರೆ ಇದೆ, ಒಂದು ಮಠ ಇದೆ, ಒಂದು ಸರೋವರ ವೀರಾಂಜನೇಯ ಸ್ವಾಮಿ ಟೆಂಪಲ್ ಇದೆ. How can you claim to be in possession?
But there are archaks there.
Yaru?
Being given the Nagegoda.
He's archak.
Yes, sir. He's being given the possession of the property. He's been cultivating the property. He's also conducting pujas there. He died 2 years back, after which my lord, his wife Maya is continuing the same thing. My lord, we've produced even photographs to show that they've been conducting the puja. And my lord, we've also examined the other members of the original trustee, the elders of the original trustees, who because they're saying that it is under our possession and we are the archers there.
The trust this is a trust property. Correct? Please wait. Please wait. This is a trust property. The property is vested in the trust. The defendants are not trustees.
But they're not the original trustees.
They are not the trustees or the original trustees. Now they are interfering with your possession of the trust property. Who are you? You are claiming under the trust.
Yes, we are being given the possession under the trust.
So therefore, you are claiming under the trust. It is a trust which has to file a suit. What is your locus standi?
All the other original trustees, a lot of law.
Then you have to.
We have examined the LRs who are parties to the original trust.
Good.
Lord, my lord, then we may please to liberty may be granted, my lord.
For what? That is always there, madam. Let the trust file a suit. Madam, anybody, if this is a public trust.
My lord, it is not denied that it is a public trust. My lord, what we are seeking is that if we in possession of the trust.
How? Your possession under the trust, madam. You are in possession of the property under the trust. If that is the case, it is a trust which has to come and protect its possession. Who are you?
Since all the other members of the trust are no more alive.
Then you file an application before the civil court saying that frame a scheme for administration because all the trustees are gone.
But then all the other contentions might be kept open so that they can file. Liberty may be granted.
This appeal is filed by the unsuccessful plaintiff challenging the concurrent finding of fact that the plaintiff is not entitled to sue the defendants and is therefore not entitled for any injunctive relief. Next para. The suit filed in OS number 9 of 2010 was for perpetual injunction to restrain the defendants from interfering with the possession of the plaintiff. It is claimed that the suit property belonged to Mayappa, who gifted it in favor of Ananta Krishnananda Mata of Bannur. Sri Hariharananda Bharati Swami of Bengaluru held control over the mutt, and he had executed a registered deed of trust dated 5/6/1950. This trust comprised of 12 members who are required to carry on the spiritual functions and to maintain the suit properties. It is claimed that one Chikka Tamaya was one of the trustees, and he was entrusted with the suit property to perform agricultural activities, to conduct agricultural activities. And his name was entered in the RTC, but the khata of the property stood in the name of a trustee named Patel Siddegowda. So after the death of Chikka Tamaya, his son Ramegowda continued in possession of the suit property on behalf of the trust. So after the death of Ramegowda, his son-in-law, his adopted son, ಅಲ್ಲಿ ದತ್ತುಪುತ್ರ ಅಳಿಯ ಹೆಂಗಾಗ್ತಾರೆ? ಅಳಿಯನೇ ದತ್ತುಪುತ್ರ ಆದ್ನಾ? ದತ್ತುಪುತ್ರ ಅಳಿಯ ಆಗಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಮೇಡಮ್. Son-in-law Nagegowda was conducting the agricultural operations, and after his death, the plaintiff was performing the puja at the mutt and was carrying on agricultural activity. Full stop. She claimed that the defendants were attempting to interfere with the possession, and therefore she filed a suit for perpetual injunction. Suit was disposed of in a preliminary issue or on all
Only on that additional issue.
the
Not
trial
other
court
four
said-
issues.
the trial court made the following.
Even evidence was led, Your Lordship.
Trial court treated the issue regarding maintainability of the suit as a preliminary issue and recorded the evidence of the parties. Based on the oral and documentary evidence, the trial court held that the plaintiff and defendant, trial court held that the suit properties belong to a trust, which was belonged to a public trust, and that the general public were the beneficiaries. Therefore, it held that the suit was not maintainable in view of section 92 of the Code of Civil Procedure, and hence dismissed the suit. Being agreed with the aforesaid judgment and decree, the plaintiff filed RA 17 of 2009. First Appellate Court also confirmed the said finding and dismissed the appeal. Being agreed with the aforesaid judgment and decree, the present appeal is filed. Learned counsel for the appellant/plaintiff submitted that section 92 is not a bar to entertain the suit for perpetual injunction. The learned counsel contended that she was in possession on behalf of the trust, and therefore she was entitled to protect her possession against the defendants who are not the present trustees of the trust. Next paragraph. If the plaintiff was claiming under the trust, she could not have filed a suit for perpetual injunction, and it was the trust alone that had to file the suit in the random note. The trial court and the First Appellate Court have rightly held that the suit was clearly barred under section 92 of the Code of Civil Procedure. There is no error in the appreciation of evidence and the application of law for the facts and circumstances. So in that way of the matter, this appeal lacks merit and the same is dismissed. It is open for the trust to take appropriate steps to protect its possession in accordance with law. Yes.
58 Rupesh Kumar.
Mr. Rupesh Kumar, there is no representation for the appellant. List after vacation. Mr. Sachin DS. Will you be asked for a password in the morning? Password at everybody.
Pursuit for
declaration to declare that GPA dated 21/9/2011 additionally have executed by plaintiff in cover defendant number 1 is null and void, is dated 4th, therefore null and void.
How are the plaintiff defendants 1 and 2 related?
Plaintiff 1 is plaintiff is a wife. Defendant number 1 is the husband. Defendant number 2 is the purchaser. The defendant number 1, the suit for declaration to declare that GPA dated 21/9/2011 produce a connection exhibit P9 is forced, therefore null and void. Number 1. Number 2 is said pursuant to the GPA executed by defendant number 1 in favor of defendant number 2 is illegal, therefore null and void. And consequently, injunction not to alienate social property.
Why did the court say that the sale deed does bind you? Why does the first appellate court come to the conclusion that notwithstanding the GPA not binding on you, yet the sale deed is binding upon you? Why did the first appellate court come to that conclusion?
I failed to prove my capacity to extend their consideration.
Now the trial court said the GPA is not binding on you. First appellate court upheld it. But the first appellate court said the sale deed is binding on you. Why?
Now, after 11 kind of time, I did not possess financial capacity to extend that consideration amount. Aduna, then define number 1 pay ಮಾಡಿದ್ದಾರೆ ಅಂತ. Exhibit B1 is saved.
Please come to the first appellate court judgment.
Yes.
112.
Page number 130, para number 30. ಹೇಳ್ತಾರೆ, it is well established principle of law that now to prove the strained relation between the plaintiff and the first defendant.
Where are reading? Where?
Page number 130.
Para number?
Para number 10 ಅದರಲ್ಲಿ page number 13. The judgment number page number 13.
30-13.
130. Page 130. It is well established principle of law that in order to prove the strained relationship between the plaintiff and first defendant, no petition or suit are required to be filed. Accordingly, the contention of second defendant cannot be considered. Moreover, in the written statement, the defendant number 2 has taken the contention that he is the bona fide purchaser of social property by paying valuable consideration. He has not taken any family dispute between the plaintiff and first defendant. According to the plaintiff, at the time of purchasing the social property, as per Exhibit B1, she has paid entire consideration. Consideration to the vendor of the Exhibit B1. In order to substantiate the aforesaid fact, no document is produced. On the other hand, the first defendant in the written statement has intended that.
Did you agree? Did you understand what I asked you? Please come to the first appellate court judgment. Go to the operative portion.
Judgment and decree dated 1/3/2017 asked invoice number so in relation, in respect of declaration of GPA dated so, these two have been executed by the plaintiff first respondent in favor of first defendant, second respondent is false, fabricated, null, and void is hereby confirmed.
Confirmed. Correct. Read the next portion.
The judgment and decree dated so past and so declaring that the sale deed dated so executed by first defendant, second respondent in favor of second defendant, apparent is null, illegal and fraudulent, and not binding and plaintiff clearly set aside. Exclude of the plaintiff involvement.
So why is it set aside is what I am asking. Please come.
ಯಾಕೆ ಅಂದ್ರೆ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಕೊಡೋದಕ್ಕೆ ನನ್ನ
Please read para 32 ಓದಿ. Para 32 page 108.
Everyone establishes that 32. The plaintiff first respondent and defendant number 1, respondent number 2 are the joint owners of the properties purchased and exhibit B1. Total 97 cents of land purchased and exhibit B1. The plaintiff first respondent is entitled for 48 half cents, and her husband defendant number 1 is entitled to 48 half cents in the properties purchased and exhibit B1. The plaintiff property is a portion of the property purchased and exhibit B1. The extent of the plaintiff property is 18 cents alone. First respondent come up this suit coming 9 cents to the plaintiff property. The plaintiff examined as DW1 in their evidence specifically stated that even after selling the plaintiff property, the property remained there. The plaintiff property. The defendant one who sold plaintiff property and the defendant number 1 is no other than the first defendant, has not been instructed to discuss. This share of property is still available in the remaining property.
ಅರ್ಥ ಏನು ಅಂತ ಹೇಳಿ ಯಾಕೆ ಅದು ಕೊಟ್ಟಿದ್ದು ಸೇಲ್ ಡೀಡ್ ಯಾಕೆ ಸೆಟಿಸ್ಫೈಡ್ ಆಗಲಿಲ್ಲ ನಿಮ್ಗೂ ನಿಮ್ಮ ಯಜಮಾನ್ರಿಗೂ ಇಬ್ರಿಗೂ ಭಾಗ ಇದೆ ನಿಮ್ಮ ಯಜಮಾನ್ರು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಸರಿನಾ ತಪ್ಪ ಸೇಲ್ ಮಾಡಿದ್ರು GPA ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಿದ್ದಾರೆ ನೀವು ನಿಮ್ಮ ಯಜಮಾನ್ರ ಭಾಗನ ಸೇಲ್ ಡೀಡ್ ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರು ತಪ್ಪೇನಿದೆ ವಾಟ್ ಇಸ್ ರಾಂಗ್
ರೀಸನ್ ಕೊಡ್ತಾ ಇರೋದು ಆ ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಹಣ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ನೀವು ಹಣ ಕೊಡ್ಲಿ ಬಿಡ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇಬ್ಬರ ಹೆಸರು ಇದೆಯಾ ಸ್ವಲ್ಪ ಕರೆಕ್ಟ್ ಮೀ ಇಫ್ ಐ ಆಮ್ ರಾಂಗ್ ಪ್ರಾಪರ್ಟಿ ಇಬ್ಬರ ಹೆಸರು ಇದೆಯಾ ಪ್ಲೈಂಟಿಫ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 GPA ಕೊಟ್ರು ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಗೆ ಸೇಲ್ ಮಾಡೋದು ಇವಾಗ GPA ಸೆಟಿಸ್ಫೈಡ್ ಆಯ್ತು ಬಟ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಗೂ ಅರ್ಧ ಭಾಗ ಇದೆಯಲ್ಲ ಸೊ ಆ ಸೇಲ್ ಡೀಡ್ ನ ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಲ್ಲ ಯಾಕಂದ್ರೆ ಆ ಪ್ರಾಪರ್ಟಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಭಾಗ ಕಟ್ಟಿದ್ದಾರೆ ಯು ಫೈಲ್ ಎ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ನಿಮ್ ಭಾಗ ನಿಮಗೆ ಬರುತ್ತೆ ನಿಮ್ಮ ಯಜಮಾನ್ರ ಭಾಗ
ರೆಸ್ಟಿಫಿಕೇಟ್ ಆಗ್ತದೆ ಯಾಕಂದ್ರೆ ಇದನ್ನ ಹಣ ಕೊಟ್ಟಿಲ್ಲ ಹಂಗಾಗಿ ನಾನು ವೇಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ
ಹಣ ಕೊಟ್ಟಿಲ್ಲದೆ ಇದ್ರು ಯು ಪ್ಲೀಸ್ ಎಕ್ಸಾಮಿನ್ ಸೆಕ್ಷನ್ 45 ಕೊಡ್ರಿ GPA ಓದಿ GPA ಇದೆಯಾ ಸೆಕ್ಷನ್ 45 ಓದಿ ಸೆಕ್ಷನ್ 45 ಓದಿ
two or more persons. And such ratio is paid across one comma. Where in the absence of contract, subject to the such property as early as may be, the interest to which they are restricted. Where such expression is made of separate funds, like into the separately, and in the absence of a contract to the company, especially related to a trust in such property in proportion to the shares of expression, which is the cost.
Next.
The absence of evidence as to the person in which they were respectively allocated or as to the shares which they respectively advanced, such persons shall be presumed to be equally interested in the property. ಯಾರು ಹಣ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕನ್ಸಿಡರ್ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಪ್ರಪೋರ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆದ್ರಿಂದ ನಾನು ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಇದು
ಕೊಟ್ಟೆ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ ಇನ್ ದ ಆಬ್ಸೆನ್ಸ್
ಇದರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಕಾರಣ ಕೊಟ್ಟು
ಪೆಂಡಿಂಗ್ ಇದ್ರೂ ಏನಾಗಲ್ಲ ದಟ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಇನ್ ದ ವೇ ಬರ್ಕೊಳ್ಳಿ. This appeal is filed by the dismissed. It is open for the plaintiff to claim her share in the suit property.
Is 44 minutes? 44 minutes.
Yes, sir.
I appear for the appellate counsel, my lord. My lord, the appellants filed a suit for partition and also to declare the agreement of sale which has been executed by the father as null and void and not binding upon the plaintiff's share. My lord, the suit has been dismissed on the ground, my lord, for the reasons that the non-inclusion of other properties of the family. And also the plaintiffs are not questioned the alienations which are alleged to have been made by the father prior to the execution of the sale deed in favor of the second defendant. The plaintiffs, my lord, filed the suit through guardian, that is mother. Then the plaintiffs made an application before the appellate court for discharge of them and to amend the plaint to include the properties which were not added as a social properties. The said application also came to be rejected. And
yes.
Respondent number 1 hearing against respondent number 2 and respondent number 3 for enforcement of an agreement for the cell. Land bearing survey number 24/1. The agreement of sale was dated 13/9/2000.
13? 2000.
Yes. This was filed on 28/2001. Respondents number 2 and 3 executed as rated on 8/11/2001 in favor of the The suit subsequently, our vendor is also pleaded as a defendant number. The suit was decreed on 26/7/2006.
23?
26/7/2006. Of course, in that suit, though they filed a written statement, defendants under 155 statement, they did not cross-examine the plaintiff, not to have for all technical purposes, it was an exposing. Then my vendor filed mysterious 28/46 for restoration of the suit. Which came to be discussed on 8/7/2009. And thereafter, he filed one more mysterious to restore mysterious 17/2009. That also came to be dismissed for non-prosecution. 11/6/2009. Thereafter, of course, this very that sort of the appellate hearing of 2010. First one, 2010. Of course, by that time, only question mark is not very few months are going to start. What is that according to the agreement in favor of Respondent number 1 here was in respect of 24/1, 24/4 million. And the land that has been sold to me is there in 24/2 million. Regarding there was a dispute regarding identification of the property. The solution once I filed an application of the section or 297, it has to be tried as a regular.
No, the decrease in respect of 24/4.
That's correct. This agent executed by in my favor is in respect of 24/2.
So therefore, the property, you are not interested in the property. Where is the family? Yes.
Same fact is categorically admitted by paragraph number 17 of the Telecast. Same fact is categorically admitted by herself. That was examination is thus. Now, over everyone member release that more number to the Delhi and approval. Authority or Delhi. Festival can Chikama or Delhi. Collector of the in the now, other level to the Delhi. He made a check for the order. The Davas of the Delhi. You offer, of course,
this is your evidence.
That's correct.
This is your own evidence.
This contention regarding the identification of the property and raised expectations for the also. What we can see. What's the connector to be on the second floor? Paragraph 28 of the judgment of the trial. Yes. I have the humble opinion that the later on the humble is in the applied to the facts. Clearly, because there is a mistake in the survey number exhibit survey number 24/2 cannot be said that the identity of the property is not have the extent boundaries and all other details are properly stated. We are number 1 and 2 admitted not possess any other property.
Yes, sir.
But you yourself admit, ನಿಮ್ಮ evidence ಇಲ್ಲ ಇದೆಯಲ್ಲ. Correct, but what is there to show that the judgment debtors had the survey number 24/2?
Only 2 doubts. One is they should have the application should have been tried as a regular. So to lot of the kind of see what is no issue of them.
So only a single point has been framed right towards the hearing was behind the scene. On page number 41, sorry, 46. Whether the applicant object the point, whether the applicant object has made out the sufficient and my only doubt is not because no issues, the proper issues are present. On framing the proper issues that contention was taken by the first applicant, before the first applicant, no finding and your lordship is not inclined to read. Only request to
Number 2000 decree. 22 years that man has not been able to enjoy the decree. Immediate.
Yeah, because your lordship has come across the number of orders passed. Why would this application to section order? You are failing. The lordship can make an observation that issue should be present.
No, but you are a pendenti lite purchaser. So therefore,
by the time of purchase, the final.
there is a bar under 102. Order 21 rule 102. Order 21 rule 102. There is a bar.
Of course, there is a final amount.
No, really. 102 no note. Rules not applicable to transfer pendenti lite.
Of course, pendenti lite are hit by pendenti.
So therefore, you don't have the benefit of order 41.
That issues are not that has
Still. Dismissed. Yes, sir.
And then it was mediation. Mediation already final already at this point.
If you want to go for mediation, and send it again.
difference part ಇದೆ.
I will ಮಾಡಿ.
The postponed 10 will also come that day.
Yes, you are ready. Ready ಇದೀರಾ? ಶುರು ಮಾಡಿ. I don't remember the facts, madam. Madam, we can't keep on posting. Don't ask for 10th. Specific performance shoot. ಏನಾಗಿದೆ?
Good for specific performance of agreement.
What has happened? What has happened, madam? Shoot
In the trial court, it was a night paper. An agreement was executed by the brothers. And in the trial court, the order was not paper. There was a RA file where we had to defend in their favor. So we are again before this court and RSA. So it's a matter of now it becomes a question of law here.
What question of law?
Now here for us the findings before the RA is saying that we had not executed that agreement. That is the major contention the appellate court takes in the judgment. Our contention is and it says that the agreement was executed. That has also been observed by the RA in the judgment. But then the final order is against So I think I will just in detail.
Case of reconveyance.
Anta our case. Original not produced.
What is the total extent of land?
1 acre, 8 acres. And this was got to the latest in the form of partition deed unit badli rehta hai. And in the partition deed, we were supposed to pay 27,000.
Both plaintiff and defendant are brothers.
Yes.
No.
They are brothers, and in 1980 there is a partition deed that happens, and as per the partition deed, there is a property which is given to the plaintiff, and the plaintiff was also instructed to pay 27,000 for so that he can construct the property. But then the plaintiff who doesn't have money at that time, he pays 5,000 rupees, and for 20,000 rupees there is a packet. First there is an agreement. There was an agreement made, which was an unregistered agreement, and later there was a sale deed registered. So the contention here is the sale deed was registered with a view that so that when I pay the 20,000 as per the partition deed, when I pay the 20,000, you are supposed to reconvey it back to me. But over a period of time, once the sale deed is done,
How much are you willing to pay?
the lordship,
How much are you willing to pay?
tried and asked.
What is the difference?
But ಅಲ್ಲಿ ಅವರು ನಮಗೆ ಪ್ರಾಪರ್ಟಿ ಬೇಕು ಅಂತ
ಆಯ್ತು, ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಬೇಕು, ನೀವು ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ ಅವ್ರಿಗೆ. ಹೇಳಿ.
Your lordship, like something we can keep the parties present before the court because the defendant ಅವರು ಬರೋದೇ ಇಲ್ಲ, ಮಾತುಕತೆಗೆ ಬರಲ್ಲ.
ಬಂದಿದ್ರು mediation ಗೆ ಬಂದಿದ್ರು.
ಒಂದ್ಸರಿ ಬಂದಿದ್ರು and later he was supposed to come back and give us some price, but he didn't come back after that and we waited after that.
It is while much beyond the time and originally is not produced. There is no such condition in the Malad sale deed forthcoming.
The point was it was as per the partition deed, but there was also
Correct, partition deed ಆಗೋಯ್ತು. Partition deed ಆಗೋದ್ಮೇಲೆ ಈ ಪ್ರಾಪರ್ಟಿ is fallen to your share.
Yes.
You have conveyed it to him.
Only with the agreement I take care of the thing is
How have you proved that agreement is a question? How you have proved that agreement?
In the cross examination of the in the trial court, the cross examination is being conducted at that time, but the signatures which was produced, when they were the confrontation of the agreement happens, he says one signature. When the signatures are being confronted, one signature he says it is not mine, another signature he says it is mine, and then he contends saying that it was taken on a blank sheet. But wherein the document, the content was there and everything was there, which was admitted before the trial court. And before the trial court, it gets admitted. And we are, since 1982, this has been going on, Your Lordship, and we've been telling from then we are ready to purchase it back, and they've not been coming, and the litigation has been happening since then. If you see that is since the first OS was filed in 99. 99 in the, see for them, my client, the years it has come through its ancestral property, even these around 72 years, and we have tried right now best to see if we can get this one side, but the party.
You don't have any other property?
Property.
Yes, how much you have? It's what I history.
Exactly.
And your people are fighting over 1 acre of land.
Yes, Your Lordship. You see, on the same grounds itself, we tried to mediate for the last time.
Exhibit P2 is the agreement.
Exhibit P2 is the agreement, Your Lordship. Yes.
How much is the amount payable under the agreement?
Exhibit P2 is the agreement initially. (1980) agreement. In the paper book, page number 76. Type copy continues.
But this exhibit B2 is the partition.
It's a partition agreement.
Where is the agreement of reconveyance?
Only they have produced before the court, only the sale deed is produced.
Where is the agreement to reconvey?
The later agreement which is there, which is not produced, because the contention before the trial court was we only had the copy. So copy in this renda we were not able to produce, saying the contention here since then was original was the defendant and to produce it. And even in the legal notice the same thing was given, even in the trial court that was a contention. And they said they do not have any copy. And even the copy was as per the documents we do not have, as per what is.
How do you prove it?
As per this, we do not have it here, but.
How do you prove it then? Reconveyance agreement has to be proved. How have you proved it?
The thing is, as reading after Prakara, as per the cross examination that has come forward before the court, it says that an agreement is shown to them and he has admitted to he has admitted to one signature on this. And there is a little confusion on that.
See, how will the court assume the facts under the reconveyance agreement?
On that point, I just want to clarify.
No, please clarify it, man. Please don't take 10 to Allah.
Sorry, Nale agala.
Don't worry. These are all very small cases, man. Don't waste time.
At least
Tomorrow. Please get ready. This is not some constitutional issue. Yes, knowledge. Settlement ಮಾಡ್ಕೋತೀರಾ ಅಂತ ಟೈಮ್ ತಗೊಂಡು settlement ಆಗೋದಿಲ್ಲ. And you don't want to argue the appeal also. Yes. Yes, Mr. Abu Bakr Shafi.
Plaintiff respondent.
Huh?
Plaintiff respondent.
Yes, nenne matter idu. Yes, Mr. Abu Bakr Shafi. Yes, there is no representation for the appellant. The appeal is dismissed for non-prosecution. Next. ಎಲ್ಲಾದು ಹಂಗೆ ಅಂದ್ರೆ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕ್ರಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್? ವೈ ಶುಡ್ ವಿ ಗೆಟ್ ದಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟೆಡ್? ಲಾಸ್ಟ್ ಬರ್ಲಿ ಅಂತ 4 ಗಂಟೆ ತನಕ ಅಡ್ಮಿಷನ್ ತಗೋತೀನಪ್ಪ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಯಾರು ರೆಡಿ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. Not even one person is ready. Just please go on. ಶುರು ಮಾಡಿ. ಪ್ರಿಂಟ್ ಇದ್ದಾನೆ ಓದಿ ಪರವಾಗಿಲ್ಲ ನಿಧಾನ.
No, which is yours? 62. Your Honor, appearing for respondent.
Please read the judgment. Trial court judgment ಓದಿ. I will read along with you. Please read. Nobody wants to argue the appeal. Is anybody ready? Both lawyers. Ibru idre heli. Ibru idira. Ibru idre heli. I'll take it up. I think both the parties are there. You please mention. I'll take it. ಅದೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತಲ್ಲ ನೀವು. ಎಸ್ ಮಿಸ್ಟರ್ ಯಾರಾದ್ರೂ ಶುರು ಮಾಡಿ. ಶುರು ಮಾಡಿ, ನೀವೇ ಶುರು ಮಾಡಿ. When will you argue? Tomorrow. Argument ಮಾಡಕ್ಕೆ ರೆಡಿ ಇಲ್ಲಪ್ಪ. ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್. Yes. Next. Mr. G. Papi Reddy. Papireddy. Nalagarh. 64. Ramayagowda. Chandraya. Gayatri TN. ಏನ್ ಮಾಡೋದು? Yeah. There's no representation for the respondent. This tomorrow. ನಾಳೆ ಬೇಡವಾ? ಯಾವತ್ತು? ಇದು ಗುರುವಾರನ ಶುಕ್ರವಾರ? This on next Monday. KV Narasimhan, Lourdes Mariappa.
Here for respondent.
Yes. Who has filed this application for early hearing?
Respondent sir.
Argument ಮಾಡಿ.
Convince ನಾಳೆ ಮಾಡ್ತೀವಿ ಸರ್. ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಸೀನಿಯರ್ ಮನೆ.
ಅಯ್ಯ ಹಾಕಿದ್ರಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ.
ಇಲ್ಲ ಸರ್ ಮಧ್ಯಾಹ್ನ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಹೋದ್ರು. ಮನೆ ಹತ್ರ ಹೋದ್ರು ಸರ್ ಏನೋ ಪ್ರಾಬ್ಲಮ್. ಸರ್ ಪಕ್ಕ ಕನ್ವಿನ್ಸ್ ನಾಳೆ ಮಾಡ್ಬೋದು ಸರ್.
ನಾಳೆ. Provision. There is no representation for the appellant and that. Say number 65. Counsel for the is tomorrow.
Much obliged.
ಆಯ್ತು ಹೇಳಿ ಸರ್ ಯಾರೋ ಇಬ್ರು ಇದ್ದೀರಲ್ಲ ಶುರು ಮಾಡಿ ಬರ್ದಿರ ಏನ್ ಮಾಡೋದು?
Serial number 66. I am appearing for the respondent, ma'am.
Yes. Which respondent? Which respondent, Mr.?
Respondent number 1.
Ready?
I seek short accommodation.
Now your argument ಮಾಡ್ತಿದ್ದಾರೆ. Please note down his argument. Yes.
Second page. That's my mother. None of my clients is a plaintiff. Krishna and Nagaraj. My brother is Chalwappa. The problem now I have is with Chalwappa. Chalwappa said about my father. That's the Victorella, all admitted facts that the relationship between the parties not in dispute. And first game, Mogalne page. It's even 5/5/1975. My client executed a power of attorney in favor of the father. This is the subject matter of the 6 acres. 2876. My father and my brother Chalwappa, they sell the property to Chalwappa's minor children. It's the dispute. Chalwappa's children are the purchasers, represented by Chalwappa's wife. The amount said to have been paid, the consideration is 4,000, all in cash. Contention of the plaintiff is my right is not conveyed there because the document per se indicates that the father sold the property. His individual capacity. I had executed the power of attorney along with my brother as per exhibit D1. The state deed exhibit D8 do not indicate that.
What is the total extent of survey 25/2? Total extent of survey number 25/2.
17.
What was the total extent? 37.
This is 6 acres.
So whatever interest that you had, you are given a power of attorney.
The power of attorney indicates this extent.
No, so whatever interest that you had, you are given the power of attorney to your father. And father sells the entire extent.
But he doesn't take my name. The CG do not indicate that he represents my clients Krishnappa and Nagaraj.
Power of attorney.
That's the only point. Other substantial question of non-house he quote on other frame. On one point. Second point is this is sold by Chalwappa along with Chalwappa to Chalwappa's minor children. So, Anandi now they are not that is a fraud that is 4,000 is a consideration. 4,000 is paid by cash. And then I issued a paper notification in 1993 Then this Chalupa, again Chalupa's wife sells the property to the outsiders. They are all business partners. So the principal contention here is that exhibit E1 and exhibit E8. Adana sort of Mikidella said that cannot. The trial court votes in my favor, though it doesn't say much about it. It's a divergent opinion. Trial court judgment, my lord,
exhibit D8 ಅಲ್ಲ
E8.
ಆಯ್ತು D8 ನೋಡ್ಬೇಕಾಗಿದೆ.
Yes, we. Then, 1976 ಆಗಸ್ಟ್ 12ರಲ್ಲಿ ಇದೇ ಹಾಸನ ಹೊಳೆನರಸೀಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಸೂರ್ನಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ಚಲೋಪ್ನವರ ಮಕ್ಕಳು 9 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ಮನೋಹರ, 7 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ಮಂಜುನಾಥ್ ಇವರಿಬ್ಬರ ಮೈನರ್ ಗಾರ್ಡಿಯನ್. ಇವರ ತಾಯಿ ಮೇಲ್ಕಂಡ ಚಗೋಪ್ಪನ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಸುಶೀಲಮ್ಮನವರಿಗೆ ಇದೇ ಹಾಸನ ಜಿಲ್ಲಾ ಹೊಳೆನರಸೀಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಸೂರ್ನಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ಚೀರಾಯ್ತು ಕಸ್ಬಿನ ಮೇಟ್ ಕೃಷ್ಣಯ್ಯನವರ ಮಕ್ಕಳು ಸುಮಾರು 70 ವರ್ಷ ವಯಸ್ಸಿನ ನರಸಿಂಹಯ್ಯ ಮತ್ತು ಸದರಿ ನರಸಿಂಹಯ್ಯನವರ 3ನೇ ಮಗ ಸುಮಾರು 30 ವರ್ಷವುಳ್ಳ ಚಲುವಪ್ಪ ನಾವಿಬ್ಬರು ಸಹ ಸೇರಿ ಬರೆದುಕೊಟ್ಟ ಕೃಷಿ ಜಮೀನು ಕ್ರಯಪತ್ರ ಅದಾಗಿನ ಮಗಳ ದರದು ನಿಮಿತ್ತ ಅಂದರೆ ಚಿಲ್ಲರೆ ಸಾಲ ತೀರಿಸುವ ಉದ್ದೇಶ, ನನ್ನ ಮಗಳು ಪ್ರಮೀಳಾ ಮತ್ತು ಅವರ ಮದುವೆ ಖರ್ಚಿನ ಉದ್ದೇಶವಾಗಿಯೂ ಕೆಳಗೆ ಕಾಣಿಸಿರುವ ಶೆಡ್ಯೂಲ್ ಜಮೀನು ಇಂಡಿಯಾ ಗವರ್ಮೆಂಟ್ 4,000 ರೂಪಾಯಿಗಳಿಗೆ ನಿಮಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ನೀಡಿರುತ್ತೇವೆ. ಕ್ರಯದ ಮೊಬಲಿಗೂ 4,000 ರೂಪಾಯಿಗಳು ಈ ಪತ್ರದಲ್ಲಿ ಕಂಡ ಸಾಕ್ಷಿಗಳ ರೂಪು ಹಿಂದೆ ನಡೆದಾಗಿ ನಮಗೆ ಸಂದಾಯವಾಗಿರುತ್ತೆ. ಕ್ರಯದ ಬಾಕಿ ಮೊಬಲಿಗೂ ಬಾಕಿ ಬರಬೇಕಾದ್ರೂ ಏನು ಇರುವುದಿಲ್ಲ. ಈ ಕ್ರಯ ಪತ್ರಕ್ಕೆ ಸೇರಿದ ಶೆಡ್ಯೂಲ್ ನೋಟಿಸ್.
Number 37.
37/6 4 acres and 37/3 ಇಲ್ಲಿ 1 acre 15, 37/2
6 ಎಕರೆ ಆಗುತ್ತಾ?
ಅದೆಲ್ಲ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ. I don't dispute. Don't may also find this substantial question of law.
When was the suit file? When was the suit file ಮಾಡಿದ್ದೆ ಅವಾಗ? '93. 23. So the sale rates are pending till it.
Not two.
ಬೇರೆಯವರಿಗೆ 93ನೇ ಇಸ್ವಿ ಅಕ್ಟೋಬರ್. This is pending till it transfers.
ಇದನ್ನ ಆಫ್ ಮಾಡ್ಬಿಡಿ ಬಿಡಿ. ಸೌಂಡ್ ಇದ್ರಲ್ಲೇ ಕೊಟ್ಟು ಮಾಮೂಲಿ.
Against the father saying that they are likely to sell them. Nantra they sold the property. That is also exhibit P1 is the sale paper copy.
How does the trial court consider this?
Yes. Trial court start agadu into page 52 in relevant page. There is 62.
Suit is decreed.
My suit got decreed, but not on the ground that I am achieving for my lord. ಆ ಗ್ರೌಂಡ್ ಅಷ್ಟೊಂದು ಇದೇ ಮಾಡಿಲ್ಲ, ಅವರೆಲ್ಲ ಅದರಿಂದ ಅವ್ರಿಗೆ ಹೆಸರು ಇಲ್ಲದೆ 1/3 ಕೊಡಬೇಕು ಅಂತ. ಬಟ್ court did not focus itself on the point of this power of attorney. But the first appellate court changes the viewpoint.
But why did you produce a power of attorney when the sale did not make any reference to the power of attorney?
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಚೆಲುವ
No.
exhibit D1. Exhibit D1. I'm the plaintiff.
Power of attorney is exhibit D1.
They produce. Exhibit D1 and D8 are produced on the other side. This is the only point ultimately for my lord's consideration. My right was not transferred. So far as the daughters are concerned, Mr. Rajiv will. page 59, last line, trial court judgment. The Chalavappa admits that there is no partition at all in the law. He accepts. In page 60, line 1. ಮೊದಲಿನಿಂದಲೂ ನಾವು ನಮ್ಮ ತಂದೆ ಮತ್ತು ಸಹೋದರರು ಆಸ್ತಿಯಲ್ಲಿ ಪಾಲು ವಿಭಾಗ ಮಾಡಿಕೊಳ್ಳುತ್ತೇವೆ. On this ground, the suit was agreed. Yes.
Let us see the first appellate.
First appellate. 18 in the starter. Right copy. Gone against me. Page 62, internal page 9, line 3. Second defendant in the written statement contained that the properties are sold upon ambiguous time. Same is questioned in the plaintiff will impact. Here in the suit, plaintiff was sought outward share of the time and does not question the sale of properties either by his father or by other members of the family. Therefore, the suit is barred by limitations of one form. Our Arjumani. Page internal page 10, page 63, page 63, line 8, 9. Thus, the plaintiff's father, under the pretext of general power of attorney, executed by plaintiff.
Internal page 10 of the first
appellate page 10 of the
first appellate court judgment.
First appellate. In page 63, line 10.
Paper book ಹಾಕಿದ್ದೀರಾ?
Okay. Page number 10. Para 17.
Page?
Page 73. ಕೆಳಗಡೆ ಇಂದ 8 line.
Page number is on the bottom or on the top?
Top. In page 73. ಕೆಳಗಡೆ ಇಂದ 8ನೇ.
Internal page 12.
Yes. Harry.
It starts with purchase by this defendant.
The DW5 underset. Age about 78 years. Retired revenue officer. ಕೆಳಗಡೆ ಇಂದ 8ನೇ. Who deposed before the court that he has paid entire consideration and purchased the property in the name of his daughter's son, namely Manohar Manjunath. This could not have been believed for the Yuriyanan. This man Rangasetti is the father-in-law of Chelvam. Father-in-law of Chelvam. He is not a signatory to this deed as I witness also. So what they project at a later stage is that consideration is paid by the father-in-law in the course of the case. But that is against the documents. 74 of the last 3 lines. It is also pertinent to note that the late Narsimaya, second defendant late Narsimaya, as a power of attorney, both the plaintiffs sold the property in favor of the second defendant, minor sons, by appointing a guardian by name Sushilamma as per Exhibit E8. This is an incorrect reading of the document. In the year 1976. And ಕೆಳಗಡೆ ಇಂದ ಮತ್ತೆ 8 line. Exhibit D1. The law is very clear. The plaintiffs have clearly admitted they have executed the power of attorney, authorizing his father to sell the suits to the property as mentioned as this. As per the agreement of the parties, the property has been sold by father, including all the parties for valuable consideration. As per law, each party is entitled for the share amount in the sale consideration. If at all they have not paid any amount, no received any amount, the remedy is only to file suit to recover the amount within 3 years from the date of sale. That's the analysis. ಆಮೇಲೆ 76 ಅಲ್ಲಿ ಲಾಸ್ಟ್ 3 ಲೈನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ 76 ಇಂಟರ್ನಲ್ ಪೇಜ್. So in view of the above decision, admittedly the plaintiffs are the parties in the sale deed. Adu tappu. So the judge goes on a note that I am a party in the sale deed, my father has acted on my behalf. All along consistently the first appellate court makes this. This is the only point. Elaborate ಮಾಡಿ. It's the only point.
Yes. We are.
Page 12, page 12 issues. Again, substantial. Thus, through the virtue of the power of attorney, issues law. His father and himself have sold the properties to Manohara, Manjunath. Within a substantial question of this is not being actually addressed.
The power of attorney is admitted.
Power of attorney is admitted. The trial court and the first appellate court does not focus on this particular issue. This power of attorney is whether the same deed has that or the other only.
Yes, Mister. Yes, please go on. Whom do you represent?
Lordship, I'm appearing for the respondent number 1. Lordship may kindly have this matter on next week, man.
No, tomorrow. Short question is involved, Mister. Is there an implied authority? No. Is there an implied authority?
Next week, my lord, kindly.
When did you witness in even Akidira?
Or Friday, even Friday, it can.
Yaru? Ilmakla kilwa. Ilmakla?
Ilmakla kya?
Tomorrow.
Lordship, this matter can kindly be taken on Friday, man.
Sorry, tomorrow. We already heard it. Anybody else? Yes, Mr. G.S. Balgangadhar.
A paper appellants, my lord. Kindly next week I'll tell you. The settlement proposal respondent. ಕೇಳ್ತೀವಿ ಸರ್ ಅದೇನಂತೆ.
ಇಲ್ಲಿ ಪ್ರಪೋಸಲ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಅವರು ರೆಸ್ಪಾಂಡ್ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಹೇಳಿದ್ದಾರೆ.
ಯಾವಾಗ ಹೇಳಿದ್ದಾರೆ?
ಈ ನೆಕ್ಸ್ಟ್ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು, ನಮ್ಮ ಪಾರ್ಟಿಂಗ್ ಕರೆಸಿ ಮಾತಾಡ್ತೀವಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎಂಡಿ ಡೇಟ್ ಮೇಲೆ.
ಯಾವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾವತ್ತು ರೆಡಿ ಆಗ್ತದೆ ಹೇಳ್ರಿ.
ಅಲ್ಲಲ್ಲ, ನಾವು ಪಾರ್ಟಿಂಗ್ ಪಾರ್ಟಿಂಗ್ ಅಡ್ವೊಕೇಟ್ ಕೇಳೋದಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ. ಪಾರ್ಟಿಂಗ್ ಏನೋ ಪ್ರಪೋಸಲ್.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾವತ್ತು ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಇಷ್ಟ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಯಾವತ್ತು ರೆಡಿ ಆಗ್ತದೆ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎನಿ ಡೇಟ್ ಮೇಲೆ.
ಡೇಟ್ ಹೇಳಿ.
ಮೇಲೆ 7 and 8 ಎನಿ ಡೇಟ್ ಮೇಲೆ. Please.
As a last chance, make clear that no further adjournment should be granted on next hearing. Is G. Papi Reddy?
Respondent by me, my lords.
Yes.
For 2 weeks' time, one of the appellant is expired.
If you allow this, then people will keep dying. Somebody should argue, Mister. Otherwise, people keep on dying.
COVID got expired and yesterday they informed.
So no 2 weeks. Appellant is expired. So therefore, LRs can come. You are for the appellant. Therefore, the appellant's children will come to you.
All the LRs have come on record, my lords. I do not know which of the LR is dead now.
Yes. Which appellant is dead?
I think one of the sisters is dead. That is what I've been informed yesterday. They said they'll get a
Where is the file?
I've been due to attend the matter.
Not his colleague.
I'm not a counsellor. I'm not in the office anymore.
I don't know whether you are in the office of G. Papi Reddy. I do not know.
Earlier I was not, so I was
A date may kindly be fixed, my lords.
Yes, who has expired according to you?
I think it's appeal number 3. One of the ladies.
Howda?
6.
ಯಾರು ತೀರೋಗಿದ್ದಾರೆ? ಚಿಕ್ಕಣ್ಣ ಗೌಡ್ರೆ.
ಅದ ನಮಗೂ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಅಪಲೆಂಟ್ ಅಂತಾರೆ. Only now respondent is only one person now.
Current counsel for the appellant submits that the appellant number 3 has expired.
Appellant number, my lords?
Which volume, my lord?
Appellant number 6.
Appellant number 3 na Pankaj Valli. 1 week time is granted to take steps. failing which the appeal shall stand abated without reference to the bench. 69. GC Street Pass.
IAPF for respondent, my lord. 69 IAPF for respondent.
No. If there is no representation for the appellant, hence the appeal is dismissed for non-prosecution.
In fact, ನನಗೂ ಏನ್ ಹೇಳ್ಬೇಕಂತ ಗೊತ್ತಾಗಲ್ಲ. ಆಕ್ಚುಲಿ ರೆಫ್ಯೂಸ್ ಆಯ್ತು ಆದ್ಮೇಲೆ ಎಪೀಲ್ ಹಾಕಿದ್ರು, ಅದರಲ್ಲಿ ರೀಫಂಡ್ ಆರ್ಡರ್ ಆಗಿದೆ. ನಾವು ರೀಫಂಡ್ ಬೇಡ, ನನಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಬೇಕು ಅಂತ ಅವ್ರು ಎಪೀಲ್ ಹಾಕಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್. ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಹೌ ಟು ಮೇಕ್ ಲಾಯರ್ಸ್ ಕಮ್ ಅಂಡ್ ಆರ್ಗ್ಯೂ, ಪ್ಲೀಸ್ ಟೆಲ್ ಮಿ.
ಮಾಡೋದು also finding it
dismiss for non-prosecution. Yes. Yes, Mr. J.G. Chandramohan, Chief Operating.
I appeal for the respondents, my lord. I represent the appeal. ನಮ್ಮ ಒಂದು ಪ್ರೆಸೆನ್ಸ್ ನೋಟ್ ಮಾಡಿಬಿಡಿ, ಯಾಕಂದ್ರೆ ನಾಳೆಗೆ ಅವ್ರು ನನಗೆ ನೋಟ್ಸ್ ಕೊಡದೆ ರೆಸ್ಟೋರೇಷನ್ ಬೇಡ.
Dismiss for default ಆಗಿರೋದು ಬಿಡಿ, ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲ, ಅವ್ರ ಅಪೀಲ್. Yes, Mr.
ನಾನು ಪ್ರೆಸೆಂಟ್ ಅಂತ ಬೇಕೆ ನೋಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇನೆ, ಮತ್ತೆ
ಪರವಾಗಿಲ್ಲ. Yes, next.
ರೆಸ್ಟೋರ್ ಮಾಡಿದಾಗ ನೋಡೋಣ.
Yes, Mr. Chandramohan, you are ready?
This is a very big matter, my lord. It may take a lot of time.
Let it take. You are scaring me.
No.
But
I am not interested to do that.
What the argument matter?
This litigation had a checkered career. Already twice it had come to the High Court.
Yes.
In fact, earlier matter was reported in 1998, my lord.
ಆಯ್ತು ಹೇಳಿ ಸರ್, ಏನು ಅಂತ ಕೇಸ್ ಹೇಳಿ.
Very same dispute.
Yes, please argue. What is the case about?
My lord, this is first defendant's appeal, my lord. First defendant, the appellant, my lord, is City Municipal Council Kolar.
Yes.
The plaintiffs, my lord, filed the suit below seeking for declaration and injunction against the against this appellant and other authorities, my lord. My lord, their claim was this suit property in survey number 163 and 164 measuring 18 untas and 18 guntas and 1 acre 4 guntas. In survey number 163 and 164, my lord, as their ancestral property.
Yes, please go on. Start with the plaint. Plaint in the Vogana.
Shall I read the plaint? Shall I read the plaint, my lord?
Yes, please.
Yes, please, my lord. Para 2, my lord. The plaintiff are in possession and enjoyment of the suit scheduled property. Originally, the suit scheduled property was land revenue assessed lands measuring bearing survey number 163 measuring 18 untas and survey number 164 measuring 1 acre 14 acres of Kolar Kasbah. The said properties are ancestral properties of the plaintiffs. The genealogical tree of the plaintiff's family is separately annexed to the plaint and same may be read as part and parcel of the plaint. The first plaintiff is the legally wedded wife of late P.R. Sampangiramaya Gupta and other plaintiffs are her sons. The suit scheduled properties are in joint possession and enjoyment of the plaintiffs. Formerly, Tulsi Sampangiramaya, Sampaya, Tulsi, Ramaswamaya, who are the sons of Rangaya, for living in joint family, enjoying the joint family properties as an absolute owners. In the year 1908, the partition was taken place between them and the said partition. The joint family properties were divided and all of them got their respective shares in the said partition deed. There is a mention in respect of the suit scheduled properties. Subsequent to the partition of joint family properties, the sons of Tumsi Narayanaya, who is none other than the son of Tumsi Krishnaya, has sold 1/4 share of the suit scheduled properties in favor of Tumsi Rangaya, son of Tumsi Sampangiramaya. The said Tumsi Rangaya is no other than the grandfather of the plaintiffs 2 to 5. Tumsi Muddaya's branch and one of share each in the scheduled properties. Similarly, two sons of Tumsi Krishnaya, namely Tumsi Muddappa, Tumsi, Naranaya had 1/4 share each. Out of one-off share of Tumsi Krishnaya in total scheduled properties and a registered sale deed dated 10/12/1999. The remaining 1/4 share of Tumsi Muddappa, his sons, namely T.N. Ramaya Shetty and T.N. Radhakrishna Shetty, have sold the remaining 1/4 share in favor of the father of plaintiffs 2 to 5. P.R. Sampangi Ramaya Gupta, under registered sale deed dated 18/10/1957, for valid consideration and delivered possession of the said property to the purchasers. Tumsi Sampangi Ramaya, being the eldest son of Rangaya and also manager of the family, other sons of Rangaya, namely Sampaya and Tumsi Ramaswamaya, have left the entire ownership of their shares in the suit scheduled properties in favor of Tumsi Sampangi Ramaya. After his death, his son and grandson, namely Tumsi Rangaya and T.R. Sampangi Ramaya Gupta, have succeeded to the estate of Tumsi Sampangi Ramaya, including the suit scheduled properties. The property got under the above said registered sale deed and also the property for which T.R. Sampangi Ramaya Gupta had succeeded. He had acquired valid title and lawful possession of the entire suit scheduled properties. All the revenue documents, including record of rights, index of lands, etc., including Faisal Patrike, clearly disclose that the ancestors of the plaintiff were the owners in possession, and after their death, the grandfather of the plaintiffs 2 to 5, and after his death, his son Sampangi Ramaya Gupta, the father of the plaintiffs 2 to 5, became an absolute owner of the suit scheduled properties. Since long time, the suit scheduled properties have lost the characteristic of agriculture, and in view of the same, in the year 1960, the said property came under the jurisdiction of Town Municipality Kolar. Subsequently, the municipal authorities have entered the suit scheduled properties in their records. The name of Tumsi Muddaya, who is no other than great grandfather of plaintiffs 2 to 5, has been mentioned in the revenue records and also municipal records as Tumsi Muddananavara Mantapa, Nagarakatte, Ashotakatte, etc., and the first defendant has accepted assessment for the plaintiff. In the year 1970, T.R. Sampangi Ramaya Gupta, the father of the plaintiff 2 to 5 and the husband of the plaintiff 1, had leased the portion of the scheduled properties consisting of building to Ananda Marga preachers, Prachara Sangha, to run the educational institution under registered lease deed dated 3/4/71, and the said association is in operation of the said building, which is in existence within the boundaries given in the suit scheduled properties. On the request of elders in the town and also on humanitarian consideration about the need of water supply, the plaintiffs have permitted the first defendant municipality to construct over a water tank, and accordingly municipality has constructed the said tank. The defendants absolutely have no manner of right title, much less possession over the suit properties, except the partition of this land in which overhead water tank above referred are constructed. In spite of that, the first defendant had tried to manipulate the documents by inserting the name of the municipality in the municipal documents in the office of the first defendant, and also trying to interfere with the lawful possession of the plaintiffs. After the death of T.R. Sampangi Ramaya Gupta, the plaintiffs have succeeded to his estate, including the suit scheduled properties, and they became the absolute owners in possession of the said properties. After noticing the proposed above referred the said properties, after noticing the proposed referred illegal acts of the first defendant municipality, the plaintiffs have filed a suit in OS 43 of 1978 before the then Municipal Court Kolar for the relief of permanent injunction, but the said suit came to be dismissed on technical ground of non-issuing statutory notice. Against the said dismissal of the suit, an appeal was preferred before the learned civil judge, the then in RA 3 of 88, but the said appeal was also dismissed. Against the said judgment and decree, the plaintiffs have filed a second appeal before the Honorable High Court of Karnataka, before Bangalore in RAC 282/1992, and after contest, the said appeal was allowed and ordered to return the plaintiff with a direction to file a fresh suit after complying the statutory obligation of issuing previous notice. After complying the statutory obligation of issuing the legal notice, again the plaintiffs have filed the suit against the first defendant for the relief of permanent injunction. There are buildings, 20 tamarind trees, Nagarakatte, Mantapa, and school buildings which are in possession of Anand Marga Prachara Sangha or in existence. The plaintiffs are realizing usage of the tamarind trees during the lifetime of Sampangi Ramagupta and the plaintiff's ancestors. Some religious functions were also held in the two scheduled properties. However, subsequent to 1981, in the office of the first defendant, illegally the municipal records have been manipulated as if that the first defendant municipality is the owner of the two scheduled properties without notice to the plaintiffs, with an intention to knock off the two scheduled properties by the first defendant municipality. The above referred manipulations of the documents have been made arbitrarily without any legal sanction by entering the name of the first defendant municipality as Nagara Sabhe. Taking undue advantage of the above referred manipulations of the documents, the first defendant along with his staff has tried to interfere with plaintiff's position and the enjoyment of the scheduled properties by denying their title and position. In fact, on 15/5/2003, the first defendant and his subordinate officials came near the spot and tried to dispose of the plaintiffs by denying their title and position. However, they have strongly resisted their illegal act and prevented them from entering into the scheduled properties. In view of their illegal acts, there is no other alternative for the purpose of protecting their ownership and possession. The plaintiffs have taken steps by way of legal action against the defendant, and accordingly they got issued statutory notice as required under the Karnataka Municipalities Act on 18/8/2003. The said notices have been served personally on the defendants, except the plaintiffs. None other have any right, title, or possession over the two scheduled properties, including the defendants. In spite of that, the first defendant is unnecessarily making illegal attempts to dispose the plaintiffs by denying their title, though he has no manner of right, title, or possession over the said property. In view of the illegal acts of the first defendant, the plaintiff has no other alternative except approaching the sample court. The first defendant is wrongdoing. First defendant is working under the second defendant, who is also a necessary party, and accordingly he has been included as one of the defendants. The separate copies of genealogical tree of the plaintiff's family, the separate Xerox copy of the registered sale deed dated 18/10/57, executed by Ramaya Setti and others in favor of T.R. Sampangi Ramagupta. Original separate Xerox copy of registered sale deed dated 10/12/18, executed by Tumsi Rangaya in favor of Tumsi Naranaya. Separate copy of registered partition deed dated 29/2/1908, executed between Tumsi Sampaya Ramaya, Sampaya and Ramaswamaya. Separate copy of Faisal Patrike. Separate copy of Faisal Patrike of the year 1837. Separate copy of the records of right, index of lands, copy of the notice issued by the Amilda, copy of the notice issued by the President of Municipal Council, Kolar, copy of the notice issued by the President of Municipal Council, separate copy of the assessment register, separate copy of the assessment register, separate copy of the assessment register, separate copy of assessment register, tax paid register dated 19/11/97, copy of tax paid receipt dated 19/11/90, copy of the endorsement dated 30/10/67, permitting the father of the plaintiff 2 to 5 to install water tap, separate Xerox copy of the lease deed dated 3/4/71, executed between T.R. Sampangi Ramagupta and Anand Marga Prasaraka Sangha, copy of the illegal notice dated 26/5/1999, copy of the notice dated 22/6/1999, copy of the legal notice dated 18/8/2003, postal acknowledgement and another postal acknowledgements are herewith produced, and the said documents are clearly established that the plaintiffs and their ancestors are in lawful possession and enjoyment of the two scheduled properties, and the defendants have no manner of right, title, much less possession over the said properties. The schedule original documents of the above referred documents have been produced in OS 335/1999 on the file of the Principal Civil Judge Junior Division Kolar. As such, a Xerox separate copy of the said documents are produced in this case. The original partition deed dated 29/2/1908 mentioned above is lost when it was produced in the municipal office. In spite of thorough search by the plaintiff, it is not traced. As such, the separate copy of the said document is produced in OS 335/1998. Xerox separate copy of the same is herewith produced. The defendants have no manner of title, useless possession of the suitable properties. Taking undue advantage of the plaintiff's helplessness and also orders passed in MA 16 of 2001, the defendant number 1 is making all attempts to interfere with the possession of the suitable properties by denying the title. The above referred legal acts of the defendants are in continuous in nature from 15/5/2003 and subsequently. Hence, the suit for declaration of title and permanent possession for permanent injunction. The cause of action for the suit arose on or before 15/5/2003 on the date of defendant's attempted interference with the plaintiff's possession over the suitable properties, and also denial of their title on 18/8/2003 on the date of illegal notice on the date of service of notice to the defendant, and subsequently at Kolar within the jurisdiction of this honorable court. The suit is valued for purpose of court fees is as per the violation slip.
Sir, we'll have it tomorrow.
Tomorrow ಬೇಡ ಸ್ವಾಮಿ.
ಮಾಡಿ ಸರ್, ಹೆಂಗು ಶುರು ಮಾಡಿದ್ರ ಮಾಡಿ.
ಎಲ್ಲ ಮಾಡ್ತೀನಿ. Could you last have it on Tuesday, my lord, 5th, 5/4.
ಈಗ ಓದೋದ್ ಶುರು ಮಾಡಿ, ಅದೇನ್ ಬೇಕಾದ್ರು ಮುಗಿಸೋಣ.
ಅಲ್ಲ, ಸ್ವಲ್ಪ ನನ್ಗೆ ನಾಳೆ ನಾಡದ್ದು ಇದಿದೆ, ಮತ್ತೆ ಹಬ್ಬ ಬೇರೆ ಗೊತ್ತಿಲ್ಲ ಇದಿದೆ.
ನಮಗೂ ಹಬ್ಬ ಇದೆ ಸರ್.
ಅಲ್ಲ ಇದೆ. ಸರಿ ಸ್ವಾಮಿ,
ನಾಳೆ ಶುರು ಮಾಡಿ ನೋಡೋಣ.
5th of April. 5th of April.
For all you know, it may not even reach, but let it be in the list.
No, I'll go on. I will not ask for time. 5th of April ತಗೊಳ್ಳಿ.
ಅಲ್ಲ 5th ಅಲ್ಲ, 5th ಬೇರೆ ಇದೆ, ನೋಡೋಣ. ನಾಳೆ ರೀಚ್ ಆಗೋದು ಡೌಟೇ, but let it be in the list.
Or may I request kindly have it on Friday.
Be in the list tomorrow. Let us see.
ಅಲ್ಲ,
it may not reach.
ನಾಳೆ ನಾಡೋದು ಬೇಡ ನನಗೆ ಸ್ವಲ್ಪ.
ಆಗೋದು ಡೌಟ್. Let it be in the list.
ಯಾಕಂದ್ರೆ ನಾಡಕ್ ಸ್ವಲ್ಪ ಹಾಸ್ಪಿಟಲ್ ಹೋಗೋದಿದೆ ನಾಳೆಯಿಂದ ಸ್ವಲ್ಪ.
ಅಲ್ಲೇ ಹೋದ್ರು
ಫ್ರೈಡೆ ತಗೊಳ್ಳಿ. ಫ್ರೈಡೆ ಮೇಲೆ
ನೆನ್ನೆ ಹೇಳಿದಕ್ಕೆ ಇವತ್ತು ಹಾಕೊಂಡೆ. Hold up. Dismissed for non-prosecution, file an application. ನಾಳೆ ಮಾಡ್ತೀರಾ? ಅದಕ್ಕೆ ಐ ಹಾಕಿ ಬಿಡಿ. ಇಂಗ್ಲಿಷ್ ಬೇಡ, ಫಿಸಿಕಲ್ ಆಗಿ ಬಂದೇ ಮಾಡಿ. ಮಾಡಿದ್ದಲ್ಲ, ನಾಳೆ ಬಂದು ಮಾಡ್ತೀನಿ ರಿಕಾಲ್. ನಾಳೆ ಬಂದು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್. Already passed. It's already signed. Sorry sir, ಐ ಹಾಕಿ ಹೆಂಗಿದೆ?
Court officer. Court officer. Court officer. Court officer. Court officer.
Sir, 76 ಯಾವತ್ತು ಸರ್?
ಅಲ್ಲ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಯಾವತ್ತು ನಾಳೆಗೆ ಹಾಕಿದ್ರ ಫ್ರೈಡೆಗೆ ಹಾಕಿದ್ರ?
90.
ಸೀರಿಯಲ್ ನಂಬರ್ 76 ಯಾವತ್ತು ಸರ್?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 70 ನಾಳೆನಾ ಫ್ರೈಡೇನಾ?
ಸರ್ ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 70 ನಾಳೆನಾ ಫ್ರೈಡೇನಾ?
ನಾಳೆ ಸರ್, ನಾಳೆ ಟುಮಾರೋ.
ನಾಳೆನಾ? ಅಲ್ಲ ಓಕೆ ನಿಮ್ಗೊಂದು ರಿಕ್ವೆಸ್ಟ್. ಕೇಸ್ ಕರೆಯುವಾಗ ತಾವು ದಯವಿಟ್ಟು ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ, ನಮ್ಗೆ ಗೊತ್ತಾಗೋದೇ ಇಲ್ಲ ಅದು ಯಾವ ನಂಬರ್ ಅಂತ.
ಮಾಡ್ತೀನಿ ಸರ್, ಆಯ್ತು ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಸರಿ ಸರ್, ಸ್ವಲ್ಪ ಮೈಕ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇರಿ. ಥ್ಯಾಂಕ್ ಯು.
76 ಯಾವತ್ತು ಸರ್? 76
ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇನಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸರಿ ಸರ್.